Yes.
My lord, one indulgence. The previous Honorable Chief Justice passed an order on 17 March 2022, directing the District Magistrate Paschim Medinipur to clean the rural agriculture area canal. But till date, content file till date.
You give the number, we list the matter.
Matter is pending, my lord, and during the pendency of the case.
No, what do you want? No, but you want a modification of that order.
No, my lord, the contempt case, the district.
But contempt application can't come before this division bench. It has to come before a division bench consisting of Justice Rashri Bharadwaj and some other honorable judge. You please give a letter on the administrative side to the OSD. I'll assign it to the bench.
Okay, my lord. Grateful.
Yes.
Lordship, may I be permitted to mention, Your Lordship, this matter is appearing in today's list as item 524. It is a public interest litigation, Your Lordship. Lordship, I had filed the instant
You want it to be upgraded.
Lordship, the urgency, if I may be allowed to place before this honorable court, Your Lordship, our facility which has been granted work order, it has not done the work, and the Pollution Control Board has finally given the final annual report from
But
where
today we can't upgrade it.
Lordship,
You
Lordship,
give the letter. Probably next week we'll try to do something.
Lordship.
Yes.
Lordship,
Grateful
I'm
to Lordship.
mentioning for a correction in the order dated 1st August 2023.
What is the correction?
Instead of Nabin Shanga, that will be Rabin Shanga, a small list.
May I be permitted to mention, my lord?
We can show it in the days list. This matter has been. In which paragraph is that?
Second page, I've marked the portion.
This matter has been listed under the caption to be mentioned. It is submitted by the learned advocate for the petty the appellant. That in paragraph 4, in the extracted portion, the name of the club has been shown as Nabin Sangha, but it should be Rabin, R-A-B-I-N. This correction be effected in the order dated 1/8/2023, and this order shall form part of the order dated 1/8/20.
Grateful, Lordship.
Yes.
Lordship, may I pray for leave to file appeal without certificate of lordship?
May I be permitted to mention, my lord, for non-prosecution?
May I permit to mention for enlistment of the matter, my lord.
May I have my lords kindly to mention a matter, my lord? This is the SGS matter. It's running as item number 116 in my lord's list, my lord. I'm praying for upgradation, my lord. It's a matter of blacklisting and there's severe prejudice.
But, this week we can't do it.
Lordship, we haven't even received notice. I'm present in court by coincidence.
My lord, my advocate record is on the way, my lord, with the notice.
That's all right. You serve notice, we'll see.
Let the mentioning be done upon notice.
Please call the list.
Appellate side, daily list, serial number 1, monthly list.
My lord, this is my appeal, my lord.
Yes.
I just
Have to keep it.
Then my lords had passed an order on the 26th of July 20.
after all, this is my appeal. I expect Mr. Shah, my lord, to have some patience so that if I'm incorrect in assisting my lords, my Mr. Shah is there.
Very well.
We are just seeing the previous order.
Yes, my lord, kindly come.
Which is the order? What is
My
the
lord, probably my learned friend is suggesting the order of 26th of July.
23.
yes.
Now, kindly see the order, my lord, once. May I file the affidavit in reply and the can numbers, my lord, because.
So there is an inspection to be done by the RDSO Lucknow.
Yes.
And an independent opinion was
Yes.
called for.
Now, my lord, in my affidavit in reply, I have the copy has been, my lord, filed earlier, in my affidavit in reply, my lord, I have annexed a copy of the
Hmm.
independent opinion and the report. Kindly, my lord, kindly come to annexure A, which is the, my lord, inspection report of the affidavit in reply.
Inspection report has been given to us separately also.
Yes, so my lord can take it separately or from the affidavit, whichever is convenient to my lord.
Hmm. Yes. Page number.
করেছে, affidavit report sub করেছে? তো দয়া করে দেখা।
We have not received any affidavit reply. Lordship will consider, my lord, the inspection report
The report
independent.
itself
Yes.
No, no, yes, but affidavit in reply has been served, my lord. No, I have got certain other documents which has been given earlier also in a compilation I've given.
Let us first see the inspection report,
Very
then we'll proceed. Page 9 is the conclusion.
Yes.
Products lot,
My
product
lord,
lot.
kindly come to page 8 once, my lord. Kindly come to page 8. Also, the fixed type of configuration poses limitation in the rearrangement of the available devices, evaluators and detection points to the track section configuration that is different to that which was ordered initially. For this, it is relevant to note that clause 5.0.1 of the specification reads, multi-sectional digital axle counter consists of axle detectors and fill units scalable up to user's requirement shall be configured and desired track section as per the user requirement specific conditions, and it demands the track section arrangements as per the user requirement. Then, my lord, considering the axle counter shell life shall not be less than 20 years, clause 10.3, requirements of such changes are there, so it is found to be non-compliant to the specification. This is one. Why I am specifying this? Kindly come to, my lord, for once, page, internal page 7.
It says the product offered for inspection fulfill the requirements of the acceptance test pro forma.
Yes.
Copies of the observations in ATP is also provided to the firm.
I will show that. I will show that.
So
immediately.
these are all technical matters.
Yes. Why
See,
will
ultimately we come, please come to the conclusion.
yes? Conclusion is, my lord.
See, is the evaluating authority not bound by this report? This order virtually was a consent order,
Yes, yes.
and this is a central.
No, the ultimate post subject to correction is, my lord, DG, Director General, my lord, safety, because it's a safety matter. Now,
So the Director General Safety will take note of this report and evaluate him.
by yes, but Director General subject to correction, my lord, we are only concerned about the safety.
Obviously,
else.
sir, everybody is concerned about safety.
Now, my lord, this report clearly says that the firm which is it is incorrect. The firm specific which
We will not go into all that. We are not here to
yes.
see.
My lord, the bogey of
No.
safety regarding, my lord,
Well, I will show.
the
Well, I will
accident
show.
device,
Well, I will show. There are 10
I've got a
reports.
completely
Yes.
clean sheet on that.
No,
my lord,
no,
from
not
the
at all.
review itself.
My lord, there are instances where it has
Yesterday.
gone to
No, no.
danger zone.
The direction issued by the learned single bench in paragraph 19.
Yes.
The respondent numbers 1, 2, and 3 are accordingly directed to commence inspection within 7 days from today in accordance with the specifications framed by the RDOSO and the ATP, applying identical procedure tests, etc. This direction will be modified by directing the respondents 1, 2, and 3 to take note of this report and proceed in accordance with this direction. So if the respondents 1, 2, and 3 are not agreeable or not acceptable, still they say they are disqualified, let them pass an order. If they are agreeable, let them challenge.
Not a matter of disqualification. my lord.
My lord,
Here,
it's a question of, my lord, yes. But kindly see what they are doing is they are supplying an unsafe system which is there in the reports. But yes.
The conclusion in the report says the product lot offered fulfill the requirement of ATP.
No, no, it says which is incorrect. There, my lord, kindly see.
You come
number
to
3.
page 9.
Yes, 9. I am now 9, my lord. Kindly see. Based on the observation, analysis found that found to fulfill the requirement of ATP, not the not the specifications.
My lord, the direction was
Kindly see.
ATP.
No, no.
The
it was
single judge
specification.
directed ATP, your
No,
lordship
subject
directed
to-
ATP.
no,
Said
subject-
nothing new will be
No,
introduced.
no,
That's your lordship's order.
specifications, we cannot go without specifications, my lord, because that will, now kindly see.
69 times
no,
the
60 no,
specifications
no.
were all right. Suddenly,
no,
my lord,
I-
they come on.
The para 18, your argument is recorded. Arguments made by the Learned Council for the Railways on the technical aspects of matter, including deployment of evaluators, according to the direction point, it's outside of the pleadings.
I will
And-
show, that was my challenge, that it was within the pleading. Which was, my lord, my.
So therefore, this is a point where you need to file a review. If suppose factual, what has been recorded is factually incorrect, we are not on appeal. We in an
Yeah, on
appeal-
appeal, my lord.
No, we in an appeal, we cannot test that. According to you, that was being questioned by you. It was in the pleadings. It's an incorrect recording of fact. Please go and get it clarified.
Otherwise, my lord, we will be remedialist. My kindly see on these technicalities. If it is not done, my lord, today kindly see. I am here to show to my lord that it was within the.
We will only, we can, if you want, you can go and get yourself clarified or review can file or some whatever application. So we will issue a direction based on this in continuation with what we have said on 26th of July.
The honorable judge's
May I-
order says also specifications and ATP. Specifications clearly says is not done. Be that as it may.
All right, if according to you, in this report, the specifications are
Not
against
compliant.
you.
Yes,
Let them consider. It's not for us to take a
very
decision.
well. And my lord, for consideration,
We go by the conclusion. The
Absolutely.
conclusion appears to be wholly in favor of the writ petitioner. You say, no, you have to read page 7, page 6. Let them break their head. Why we are worried? Neither you are a technical person or your friend is a senior, nor we are a technical people. It is up to the authorities to consider what is safe, what is not safe.
Lord, kindly just see one paragraph of your lordship's order, paragraph
and my
4.
lord,
One paragraph of
one
your
more,
lordship's order.
the highest authority of safety is my lord DG safety. He is a member of the board.
The direction is to respondents 1, 2, and 3.
Yes.
Let us see who are the respondents 1,
Yes.
2, and 3.
1, 2, my lord,
One is the
union of-
research and design organization. 2 is the principal secretary, and 3 is the executive
concerned.
director of the RDSO. Matter of they will constitute a team. They know better. Sir. They know better.
Only one thing is, my lord, your lordships have recorded in the previous order that, my lord, ultimately, my lord, the railways is being put to a loss of 1100 crores. They're very detailed, my
No,
lord.
my lord,
recording.
this
My lord,
is-
may I just
This is a
answer?
submission. No,
No,
I
that
have
is the
alternated-
finding of the learned
No.
single judge. That is, my lord,
No,
what your
I have
lordships have on
challenged that.
inspection of,
My
my
lord, this is not fair, my lord.
well,
When I
kindly have a look
submitted-
at, my lord, what your
When I
lordships have
submitted,
recorded.
my lord observation was, this is the submission, we are recording it.
We can do one thing. We can leave all issues open.
Well, kindly, my lord, the matter has been concluded. My lord,
No,
now, my lord, I cannot be, my
Yeah,
lord,
in
put
the-
back to, my lord, square one. Your lordships will
No,
kindly,
you will not be put back.
my
to
lord,
square
kindly see paragraph 4 of your lordship's
The
order.
direction in para 19 will be affirmed. Only thing is, we'll add that the report of the RTUSO Lucknow will be taken note of by the respondents 1, 2, and 3, and they will comply.
My lord,
with
the learned single judge had, my lord, directed, my lord, inspection once again. It was inspected, acceptance test reports passed. They refused to give me, my lord, clearance certificate so that the goods could be, my lord, supplied. My lord, that is
So
when
now
my
they
learned friends came.
they will redo the exercise based on this report, which prima facie in our view is fully in your favor.
Well, once again, my lord, inspection. Well, inspection, my lord, done. Acceptance test reports given.
No. Otherwise, this order and this report becomes meaningless.
No, my lord, if lordship kindly sees, my lord, the inspection report.
That's what we can do today, sir.
My lord,
If you are
I,
agreeable.
my lord,
Otherwise, we'll fix a date
my
for
lord,
the
kindly,
hearing.
kindly, my lord, just see, my lord, my lord, your lordship has seen the report. My lord, this is, my lord, the inspection that they did.
That we'll not go
Everything
into.
is passed in my favor.
They will take a decision based on this report.
My lord, they have, my lord, now, my lord, they are seeking to change the, my lord, may I just say this?
Then we'll
Well,
fix a
this-
date for hearing.
well, well,
Because
well,
there are so many motion cases, sir.
My lord, may I just say, my lord,
Doesn't
very
matter.
briefly. My
That's
lord, your lordships are considering the appeal. My lord, if your lordships is
not
satisfied,
today. No, we can't hear the appeal today.
my lord, if your
If you
lordships
want,
is,
we'll fix a date for the appeal. That can't be in September. It can be only in October.
my lord, I will be completely ruined, my lord. That
So
is why your
therefore,
lordships have, my lord.
For the best order you can take is, we dispose of the appeal by slightly modifying the order passed by the learned single bench. In addition to that, they have to take note of this. That's it.
My lord, this report, my lord, if my lord not considered, my lord, in the right context, my lord, again will be constituted to be
Yes,
against
yeah,
me.
well, it's a fresh cause of action.
No, my lord, your lordship, my writ petition was that, my lord, you have to test it in conformity with the parameters that you had set down.
Therefore, we'll hear the appeal. We'll fix a date sometime in October, second week of October, we'll fix it. Because we are thoroughly stuck, sir. All these continuing
It's very
matters.
safety and
uh,
May I
entire
request
nation
your
is
lordship,
involved.
my lord, kindly take it up sometime in September.
September
The-
is
the
not
one-
possible, sir. If it is possible, feasible, definitely we will agree.
My lord, then, my lord, may I request your lordship, my lord, for an early date in October, my lord. If possible, my lord, if in the first week of October. Because, my lord, otherwise, my lord, I will be completely without any remedy.
No, the entire safety
It's
and
an
the
MSME
accident
company,
is
my lord, at the end
taking
of the
place,
day.
my lord, there are reports.
All right.
My lord, kindly just see what my learned friend says, accident. I have got a completely clean sheet in respect of the Odisha matter.
We have not taken note of that, sir.
That's it.
Earlier, yeah, we have heard so and so. Earlier, no, by order dated 26/7/2023, after taking note of the submissions made on either side, this court issued a direction for an independent inspection to be done by the RDSO Lucknow without in any manner being influenced by the report drawn by the RDSO Kolkata. The operative portion of the order reads as follows. Please quote from para 7 to 12. If pursuant to the above direction, the RDSO Lucknow has conducted the inspection and submitted its report. The conclusion drawn by the RDSO Lucknow is to the following effect. Sir, in this inspection report, page 9, is my conclusion. In the light of the above report, we were inclined to slightly modify the order and direction issued by the learned single bench, dated 17/5/2023, more particularly the direction issued in paragraph 19, by maintaining the findings and observations made therein, and by including one line by directing the concerned authorities, namely the respondents, respondents 1, 2, and 3 in the writ petition, to carry out the directions issued by the learned single bench, by also taking note of the report drawn by the RDSO Lucknow dated 11/8/2023. The learned senior advocate appearing for the respondent petitioner submitted that this may result in prejudice to their client, as the matter will be taken to the stage 1, which will not be conducive. Therefore, it is prayed that the appeal itself be heard out at an early date. Considering the business of the court, the earliest date which can be assigned for the appeal to be heard is on 9th October. Let the appeal be listed for hearing on 9th October 4th October.
I'm very good.
Full stop.
Very good.
Since all the relevant documents are available in the stay petition, the filing of informal stay petition as well as in the applications, the filing of informal paper book is dispensed.
And my lord, the contempt application is coming up on this Friday, my lord, 1
All
October.
right. No, there is already an order of stay.
No, there's no order of stay.
Well,
Only a prayer
Your
that they will
lordship
not
had
proceed.
said that, my lord, we
No,
will
no,
not
what
proceed
is-
with the contempt.
No, no, I thought-
In the light of the above direction, we request the learned single bench to defer the hearing of the contempt application.
Grateful.
My lord,
Thank
deeply.
you.
Serial number 2,
My lord, this is
Yes, my lord, this is my appeal petition, my lord. Here, lordship, I have alleged that for the safety, security and integrity of our country and against the unauthorized and unlawful immigration from the Bangladesh through international border. Here we have an international border known as Bagda. That is an assembly constituency in a scheduled caste, and it is under the parliamentary constituency of Bongalo parliamentary constituency. My lord, here what I have alleged, my lord, I have made several representations, complaints before the election officer and as well as the State Election Commission and the Election Commission of India and the Home Ministry. My lord, what happened, my lord? The private respondents hearing, they are actually the original belong from Bangladesh, having their name in the Bangladesh voter list, but somehow they have managed to incorporate, induct their name in the Indian voter list, my lord. My lord, if you lordship kindly see. My lord,
What happened to your representation?
lordship,
What happened to your representation?
nothing has been.
May I just only indicate, my lord, I have received instructions right now, my lord, from the BSF, my lord, to apprise the honorable court, my lord, that though there are prayers made against the Ministry of Home Affairs, my lord, the Union of India, it has not been implemented as a party respondent. It is only the inspector of BSF, my lord, who has been implemented as a party.
And
my lord.
what is the role of Inspector BSF?
Yes, well, what happened? Lordship, it
No,
is a
his
very
role is over, sir.
no. Their role is not over because of the fact. But during the year 2011, some 5 activities of Jamaat-e-Mujahideen entered into the state from Bangladesh. In the year 2017, the Border Security Force seized 517 kgs of gaja and arrested some Bangladeshi citizens. My lord. So this Bagda constituency having a very hit listed area, my lord, I have made party to the.
No, what is the direction you seek against?
I seek
BSF?
direction. I seek direction upon the Election Commission for
That is
check
correct.
the voter list. Yes,
No,
and
so far as BSF is concerned, their role was limited for conduct of the election.
lordship,
Pursuant to court orders,
lordship,
the deployment of forces were there.
absolutely.
Now the forces have gone back. All the officers have been pulled out. The establishment is not available now. So we can't issue any direction to the BSF. But State Election Commission,
Absolutely.
you can very
No, only here, my lord, I think, my lord, on behalf of state, my lord, I have gone through the petition. It appears, my lord, the main prayer is, my lord, for deletion of the private respondent's name from electoral, my lord, the
Of this country.
of roll. Now, my lord, kindly have a look. My lord, before that, my lord, in 2022, that complaint was made against those private respondents. Now, my lord, prior to that, in the police station, a complaint was made against 2 private respondents, those by the petitioner before your lordship, that those 2 private respondents, my lord, fraudulently acquired a portion of his land. And my lord, filed a FIR. Now, my lord, police filed, my lord, that, my lord, under section 466, 467, 468 case, and then charge sheet already filed and they surrendered and obtained bail. That was in 2019.
So
now
that-
this, my lord,
that's the background for this
that is,
PIL.
yes.
No,
And
lordship,
now, and
my
there
lord,
is no, my lord, the general cases, my lord, made out, 7 except these 2, my lord.
But one thing, sir,
lordship,
the electoral roll has been drawn. It would have been published as per the normal
Yes.
procedure. Anybody can raise an objection. Inclusion, exclusion can be done. Suppose a person says that I am a resident, but my name doesn't find place. He has got a window. He can give. Now that is over. Elections were conducted. Now at this juncture to say remove him, it is probably in the next election. This
well, kindly direct them to at least to dispose of my complaint by the election of the officer.
There are 2 folds of submission against us. One is to appoint NIA and all this, CBI NIA. That cannot be done because ECI only just conduct election, my lord. Other than nothing, my lord.
your DSG has got better work to do.
Yes, my lord. That is Ministry of Home Affairs have to do that. But second prayer, my lord, they have never given any complaint to the electoral registration officer, ERO. They have to make a proper complaint over there. Thereafter it will be investigated.
And
thereafter, yeah, not
there
given any
is a-
Straight away, you
there
can't
is a-
jump to the state
there's a
election.
particular
Lordship, I
form that
have
form
lost the
has to be
complaint to
filled
the
out.
officer of election in charge.
Page number
Lordship, kindly come page 33 in your lordship's brief.
33.
But that is not the proper.
A
Officer of the election in
specified
charge.
form is to be filled up.
Yes, my lord.
Everything, my lord, there is, my lord, the
For
rules
electoral
are there.
registration officer.
rules are there and my lord, before the proper procedure.
Now
has to be-
this man, officer, election in charge has become functus officio.
Yes.
Lordship, I lodged this complaint during the year when the voter list of the last.
You should have come earlier, sir. You should have come in September. Last September whenever the voter list was finalized. When was it finalized?
The last vote
In
in
the
two
November.
occasions.
November 2022.
Thereafter 23, before the Panchayat election also.
My lord, this is not the proper person to be given the representation, my lord.
Please come. This writ petition filed as a public interest litigation seeks for varied prayers. Much of the prayers sought for cannot be granted in this writ petition, nor the appropriate respondents have been implemented.
Yes.
After we have heard the learned government council appearing for the state respondent state, who made his submissions based on written instructions given by the officer in charge, Bhagda Police Station, North 24 Parganas District. It is seen that the present writ petition is not a genuine public interest litigation, as the petitioner has certain personal grievances against the private respondents in the matter concerning a removed property, which is now subject matter of a criminal case in charge sheet dated 31/5/2019 under sections 465, 467, 468 and 34 IPC. And the matter is now pending. In the light of the above, we are not convinced that the present writ petition is a public interest litigation. Apart from that, the prayer sought for is to delete the names of the private respondents from the voter list, alleging that they are Bangladeshi nationals. This aspect has to be dealt with at an appropriate stage by the appropriate authority and not at this juncture when already the voter list has been drawn. The elections of the panchayats have already been concluded. Therefore, in this writ petition, no direction can be issued as sought for by the writ petitioner. However, this will not preclude the writ petitioner from pursuing his remedies before the appropriate authority in accordance with law. Next.
Get
Affidavit service be kept in record. I'm grateful to you.
Serial number 3.
Serial number 3, my lord. I beg to appear for the petitioner, my lord. This matter relates to, my lord, corruption in school uniform, my lord. There is embezzlement of 8.8 crores, my lord, by the Milan Mahila Mahasangha of Golpokhar 1, district Uttar Dinajpur, my lord. My lord, I have served the copy, my lord. There are 40 respondents, my lord. I have served the copy upon all, my lord. Served
Now,
except, my lord.
What is the allegation?
The allegation is that, my lord, the Milan Mahila Mahasangha of Golpokhar 1 block district Uttar Dinajpur, my lord, is the self-help group, my lord. This Mahasangha, my lord, interested with the duty for production and distribution of school uniform, my lord, to government school class 1 to 7, my lord. But, my lord, it appears from the bank statement, my lord, that the office bearer as well as the near and dear one of the office bearer of the Mahasangha, my lord, they have, my lord, withdrawn, my lord, crores of money in a day, my lord. My lord, I have annexed all the document, my lord, where from it appears that, my lord, the members, the post holders, my lord, of the Sangha, my lord,
They have siphoned.
Lordship.
They have siphoned the money.
Lordship, they have siphoned, your lordship, they have siphoned the money, your lordship.
But they have not supplied any uniforms.
No, your lordship.
That is, my lord, may I tell you, that is not the grievance. If you lordship kindly, if you lordship kindly have a look, my lord, the complaint at page number 44. It is not a, my lord, any amendment in the petition nor in the complaint that without supplying the uniform, now, my lord, the money has gone to their account and they have siphoned it. It appears that whatever their own bank account, their own fund, my lord, that is being siphoned or being, my lord, fraudulently taken away by others, my lord, the office bearer. But, my lord, state has nothing to do. So far, my lord, I have understood, my lord, that whatever.
Now, what action the district magistrate took on this?
The district magistrate, my lord, the BLRO, if you lordship kindly come to my lord, I'm coming to the my lord.
Page 37, your lordship.
37,
After page 37, page 35, your lordship.
35.
After page 35, your lordship, this is the my lord obtained from internet, my lord. That how this scheme will be run, my lord. For to supervise the scheme, my lord, there is a monitoring process, my lord.
On page 48
and
is
my
the
lord, under
reply.
that scheme, my lord, the district magistrate as well as there are other authorities are also there, my lord. And the block development officer, my lord, the circle inspector, the corporate inspector, the district education officer, they are the authorities were interested with the duty to supervise, my lord, these schemes, my lord. But, my lord, it appears from the action and or inaction by the same authority concerned, your lordship, that despite repeated complaint by the petitioner, your lordship, the same authorities, your lordship, they have turned, your lordship, blind eye, your lordship.
Well, page 40.
My lord,
In the complaint at page 44, they say, second paragraph. But on some reliable sources and on online database information, there has been embezzlement of huge amount of rupees after asking the concerned bank from the
Account statements of Mahasangho, that is
it
the
is found
NGO.
that there are several recipients who are local so-and-so leaders, never registered dealers of garment or anything. They have received huge amount of money from the Mahasangh without supplying any garments or cloth. That is the allegation. The DM could have at least inquired into the matter.
my lord,
Let him inquire into the matter.
My lord, I think, my lord, from
Let him inquire into the matter. Otherwise, by the time you serve all 40 respondents.
Lordship, I have served, your lordship. I have served all, your lordship. I have served all.
But what about the return?
Only, my lord, 3 or 4 return back.
So therefore, we have to issue notice. So be satisfied for the person. We'll direct the district magistrate to inquire into the matter, issue notices to all the persons, and then they will take
there is no problem.
Lordship, in the meantime,
May I
your
think,
lordship, kindly keep the matter pending, your lordship.
No.
What happened, my lord?
That is,
What happened?
you can't say what sort of order we have to pass.
My lord, why I am praying, your lordship, this, your lordship, before this honorable court, your lordship, because, my lord, the same authority is overburdened, your lordship. It appears from
Your court is also overburdened.
lordship.
Court
No, your
is
lordship,
also-
because, your lordship, otherwise.
No, be satisfied with this. No, at the admission stage, you are able to get this. By
Lordship,
this
my lord, only
protected
thing,
litigation.
well, just my lord, only thing, well,
You consider.
only thing, well, I shall, my lord, only thing, my lord, so far this
list of-
complaint, so far this complaint is concerned, my lord, I think, my lord, the tenants and my lord, the meaning of the complaint is that, but somebody received from the fund of the, my lord, this, my lord, the NGO, but without, my lord, supplying anything to the NGO.
My lord, kindly have a look, page 76
And
on.
so
Kindly.
they are not entitled
Page
to.
76
Entire
the
thing
list
is regard
of-
to the, my lord, the fund of the NGO,
Page 76.
not regarding, my lord,
My lord, page
the,
76 is
kindly
the
consider this paragraph.
My lord, page 76 is the list
That
of.
the office bearers, এক মিনিট আপনি একলাই কি বলে যাবেন না স্যার স্যার বলে তো হবে না আমাকে
Place
বলতে
করে
দিতে
দাও,
হবে
ভালো
তো।
হয় না, স্যার, আমার কেসটা?
না না কেসটা
Page
কিছু না
76 on
but
what are the list of
on
private
reliable source
participants, your
that the
lordship.
fund of the NGO is being
Serial-
siphoned out.
serial-
This is, my lord, lordship, kindly, then my
Now, who allots the fund to the NGO?
my lord, that is, my lord, I think, my lord, though no specific instruction, but I think, my lord, through the, my lord, there is a scheme.
This is
It's a scheme,
It's a scheme
My lord.
floated by the government.
my lord.
If suppose there is some misappropriation in the distribution of funds, obviously you can inquire into
Very good, lordship.
by this writ petition, the
Page
petitioner.
77, my lord, serial 14, one
Yes, yes,
crore. Same day, your lordship, withdrawn, your lordship. By the private
petitioner
recipient, your
alleges
lordship.
that there has been large scale embezzlement of the funds allotted to Mahasangh, who has been engaged to our supply of school uniforms for students of class 1 to 8 in Gola Poker number 1 development block, page 44 it is there. GOALPOKHER 1 development block. Admittedly, the project for supply of uniforms has been made, is a project of the government of West Bengal. And if there are any allegations with regard to alleged embezzlement of the funds, which was allotted for a public purpose, obviously the authorities should look into the matter. In this regard, a representation has been made to the district magistrate Uttar Dinajpur. Which respondent? fifth respondent, which has been also received by the office of the district magistrate on the very same date. Without going into the allegations made by the petitioner in the representation as well as in the writ petition, as we are disposing of the writ petition without calling for affidavits, we would direct the fifth respondent, namely the district magistrate Uttar Dinajpur, to consider the representation dated 3/5/2023, issue notice to the private respondents as well as all other concerned, call for the necessary records, and examine as to whether the allegations made by the writ petitioner are made out or not. Full stop. The petitioner shall also be put on notice so as to enable the petitioner to place all the documents which are in his custody to support the allegations. Such inquiry be conducted and an order be passed by the district magistrate on merits in accordance with the law within a period of 8 weeks from the date of receipt of the server copy of this order. The petitioner is directed to submit a copy of the representation dated 3/5/2023 and all other documents in support of their contention, along with a copy of this order, and place the same before the fifth respondent for compliance with the above direction. It is made clear that we are not gone into the merits of the allegations made, and it is for the district magistrate to inquire into the matter. Yes. Next.
Gate number 4. Extremely grateful. Lord, may I submit? Every service.
On a number,
yes.
Item 3, my lord, I am for the respondent number 3.
Where
The
for the
project director, no copy has been served, my lord. Upon the, I am the one of the answering respondents, man.
copies have been served to the legal remuneration department, my lord.
But Pashchim
Copies have been served and affirmation is being made.
Matter relates to service matter. Matter relates to service.
We have got the copy.
That's what we are seeing the prayer in the writ petition. Appropriate designation of CLRC, CRC coordinator or assistant sub-inspector to a Shiksha Bandhu. How this can be a PIL, sir?
Yes, my lord. My lord, I have dealt it in the petition itself. Still, I am giving my written submission as well as copies to them, and I'm reading out. My lord, by this PIL, we want to unearth the malpractices and maintain probity and morality in the governance of the state. The probity is a sine qua non, my lord, for an efficient system of administration, and an important requirement for ensuring probity in governance is the absence of corruption. My lord, this PIL is not restricted to only a few Shiksha Bandhus only, but thousands of them who are spread throughout the length and breadth of the state of West Bengal. The central purpose of filing this PIL, my lord, is the strict adherence to law and rule of law and principles of natural justice to all sections of all state government employees who are facing discriminatory treatment, my lord. And the government is supposedly committing financial irregularities by siphoning the 60% grant given by the central government, my lord. The Shiksha Bandhus are not getting not even that 60%. They are not getting the 40% of the state government also.
In the points of law which you have said in the writ petition, one of the prayers is whether regularization of or absorption in the regular cadre is barred fully in a welfare state. Then you say that some employees have been engaged permanent and continuous as contractual employees.
Yes.
Then you want whether higher minimum qualification should be. All are touching upon service matter, service issues.
My lord,
even organization consisting of this Shiksha Bandhu or these coordinators, they had come forward to the writ petition is fine. They are all working without raising their voice.
My lord, I will engage your attention to page 40 of my petition kindly. Please come to page 40, my lord.
Let the aggrieved person come, sir.
My lord, these are the 10 which we could arrange, we could collect the 10 instances of writ petitions filed by the individual petitioners or the group of the petitioners or their organizations. No result has come except in 2 cases, my lord. That is in serial number 6 and serial number 10. And in these 2 writ petitions, my lord, your lordships
had given the finality. And in remaining 8 petitions, the respondent government has been not filed their affidavit in opposition. They are languishing for years together, for 15 years.
Now, serial number 4.
Pardon.
See, please see that.
Yes, my lord.
Paschim Banga Primary and Upper Primary Shiksha Bandhu Samiti.
Yes, my lord.
It's an association. They
Yes, my
can
lord.
very well canvass the case. See, the Supreme Court says High Court don't issue a direction for regularization. A contract employee with eyes wide open, he signs a contract for 3-year contract, 5-year contract, 6-year contract. And after having worked, he says, no, please regularize me. In a writ petition, after Uma Devi's case, where is the
My lord, being the petitioners, we had been Shiksha Bandhu. We have retired. We are not drawing any benefit out of this petition for ourselves.
No, correct, sir.
Shiksha
But then
Bandhus,
let the aggrieved person come.
my lord, aggrieved person have already
All
filed
right,
these
then what you
petitions.
can do is,
And no.
the petitioners are retired Shiksha Bandhas.
Yes,
So
retired.
let them intervene in one of the, let us say, serial number 4. Serial number 4 is by an association. Serial number 4, page 41 of your
Association.
You file a petition to implead yourself, intervene in the proceeding, and support the petition.
But my lord, in several petitions, the objectives and the prayers are different. Prayers are different.
But PIL we can't entertain.
If my lords want, my lord can bring all the petitions here.
No.
That will be good for
That
us.
can't be done, sir.
Because madam,
Even
for years together, madam, see,
But,
2015,
what you say is correct.
2013.
We fully sympathize with the people who are working as their service conditions are very bad, admittedly very bad. But in a PIL, to issue a direction that they should be designated so and so, they should be regularized, they should be given this particular scale of pay, their provident fund should be at this particular rate. How in a PIL to do that?
My lord, individual writ petition is not working, and they have given up. All the
That you have to
petitioners,
mention probably upgradation, etc.
my lord, due to poverty or some other reasons, they have given up.
No, therefore, you intervene in one of the proceedings. You mention that application, you file a CAN application. In fact, serial number 6 is already disposed of, which is a prayer for inclusion in the Provident Fund from initial appointment. Order has been passed on 8th of March 2022. Whether any appeal has been filed against that order?
Which one, my lord?
Page 41 of your petition.
Yes. Page 40.
Page 41, serial number 6.
Serial number 6.
What was the prayer? Inclusion in the Provident
It
Fund.
was passed by your lordships, my lord. It is available in page 269. The order is available in page 269. And that has been again challenged, and they have not complied with. They have
Contempt is pending.
Contempt is gone. They are taking the separate line of action. That is
this matter,
Sarvashikha
in this matter, I appeared. Now, your lordship, I appeared for the Sarvashikha mission. Now, it was taken up by your lordship, and my lord, your lordship was pleased to direct that if there is any scope of exemption, the Sarvashikha mission should approach the Ministry of Labor. So accordingly, we approached, and we have been exempted, my lord, for the period from 1999 to 2015. 2015 onwards, we have been paying, my lord, the Provident Fund dues.
But this was an appeal by the state project director.
Yes.
That was dismissed.
That was dismissed. Yes, dismissed.
That was dismissed.
That
That's
was
what they are pointing out.
Yes.
By this public
But
interest
they have not
litigation-
taken any favorable action, my lord.
By this public interest
My lord,
litigation.
can
the
I
petitioner-
engage your attention kindly to my synopsis, one page synopsis only?
Yes, page number. Points of law. Synopsis, yes.
Synopsis, my lord.
Yes. By this public interest litigation, the petitioner
This can be
focuses the issues for the in-service Shiksha Bandhus and has sought for various reliefs, including grant of various service benefits to the Shiksha Bandhus. The petitioner is a retired Shiksha Bandhu who would state that they have no personal interest in the matter, but are trying to expose the cause of the Shiksha Bandhus who are now discharging their duties without proper emoluments and benefits. In the writ petition, the petitioner has listed out certain points of law. On perusal of the same, we find the petitioner seeks for fixing appropriate remuneration and designation as per the qualification and job responsibilities of the Shiksha Bandhus.
I'm sorry to intervene, my lord. Last hope will be dashed.
What to do, sir?
Only 2 petitions got finality under your lordship.
So in one matter, both matters it came before us. Serial number 10 was a public interest litigation
10.
where they were not allowed to contest the panchayat election. We issued direction.
I appeared for that, my lord, and you had given the order. My lord, in your order, you have
We make
recorded.
some observations here.
My lord, you have recorded that the permanent employees of the
petitioner also
and they are entitled.
questions the action of the state government in continuing the employees as contractual employees and meting out discriminatory treatment and without regularizing or absorbing them in the regular cadre. Though the cause brought before the court appears to be laudable, we are precluded from granting any relief in this petition filed as a public interest litigation, as essentially the dispute or issue is a service matter. And if it is a service matter, then a public interest litigation is barred. As could be seen from the writ petition, more particularly in page 40 and 41 of the writ petition, the petitioner himself has listed out listed out 10 writ petition numbers, some of which have been filed by association consisting of Shiksha Bandhu as its members. In one such writ petition, the prayer sought for was by the association was for payment of actual remuneration as per 65% plus 35% of central and state component. Another writ petition seeks for direction for paying revised scale of pay under the 6th Pay Commission. Another writ petition has been filed for payment of arrears of salary. In another writ petition, there is a relief. The relief sought for is that the remuneration which is much below the Group C and Group D has to be increased. There is also a prayer for raising the service tenure up to 65 years. Admittedly, out of the 10 writ petitions which have been listed out, 8 writ petitions are still pending. The learned advocate for the petitioner would submit that the relief sought for in this writ petition is a comprehensive one, and it would cover all Shiksha Bandhus. However, noting that the relief sought for directly touches upon the service benefits which are to be extended to the Shiksha Bandhus, we are unable to entertain the writ petition nor grant any relief as sought for with the writ petitioner in this petition.
As a last order, my lord, can I have your attention page 19? Page 19,
Yes,
my
sir.
lord. As a last resort, my lord, page 19. These are the series of representations, my lord. And you see the last column result, nil. Nil, 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 all nil.
The learned
Series of
advocate for the
representations.
petitioner also pointed out that several representations have been given commencing from the year 2016 to various authorities, and none of the representations have been considered. In our view, the aggrieved person has to agitate his grievances before the authorities or before the court. And we find that 10 such writ petitions had been already filed, 2 of which have been disposed of. In the light of the above, while declining to grant the relief sought for in the writ petition, we grant liberty to the petitioner to intervene in any one of the writ petitions which is pending before the learned single bench, where the relief sought for is a comprehensive relief, and the petitioners are an association, and assist the court in coming to a right conclusion. With the above observation, writ petition is disposed of. The single bench is here, it is not assessed. Next.
Serial number 5.
That I am read by Mr. Nayak, my lord. My lord, very innocuous prayer, my lord. Page 26, my lord, Annex P4 should be considered by the assistant engineer. My lord, what happened? There are several private respondents encroaching the public lands, PWD lands, and water filled up the water body, and constructing the multi-storage building, running their business, resulting the local people facing typical.
The private respondents have been served. Affidavit of service.
Earlier occasion we have served. Subsequent matter was appeared, my lord, just before my lord Justice Subhra Ghosh. Since public interest involved in this matter, therefore release the matter.
By this public interest litigation, the petitioner alleges that the private respondents have illegally encroached the government land, which has to be preserved as a water body. In this regard, several representations have been given by the petitioner to the various authorities, and since no action had been taken on those representations, the petitioner has filed this public interest litigation. Though it appears that the respondents were served and affidavit of service was filed when the writ petition was you strike out that it is submitted by the learned advocate for the petitioner that the private respondents have been served even at when the writ petition was pending before the learned single bench. However, today none appears for the private respondents. However, since we are disposing of the writ petition without calling for affidavits, the merits of the allegations made in the writ petition or in the representation are not gone into and are left open to be taken note of by the concerned authorities. In the light of the above, the writ petition stands disposed of by directing the fifth respondent.
Assistant engineer, my lord, respondent number
5.
5, my lord. I'm grateful.
Fifth respondent to consider the petitioner's representation, issue notice to the private respondents and all other concerned, and then take a decision on merits and in accordance with law. In order to facilitate the compliance of this direction, the petitioner is directed to forward the copies of the representation already sent, along with a copy of this order, to the fifth respondent for compliance of the above direction. The above direction be complied with within a period of 6 weeks from the date of receipt of the server copy of this order.
Time may be framing, my lord.
6 weeks.
I'm grateful.
It will make clear that allegations made in the writ petitions are not gone into and are left open to be considered by the fifth respondent in accordance with law. Next.
Serial number 6.
Lord, I appear for respondent number 4, 5, 6, and 7.
Yes, sir. Yes.
But in 2006, the government of India introduced the National E-Governance Plan, wherein this to deliver the government scheme directly to the government to citizen, a proposal has been made for set up the common service center. Now, in 2015, under the flagship program of Digital India, the common service center 2.0 introduced. Now, it is the primary object is to set up in 2.5 lakhs gram panchayat. Malad 2.5 lakh gram panchayat and Malad and every gram panchayat there is a common service center. And Malad this CSC Malad implemented in PPP model. Malad and Malad with an entrepreneurship in village level. Those are called Malad village level entrepreneur, that is VLC. Now Malad presently Malad there are 42 banks and 29 ministries directly linked with Malad these CSC centers. And Malad at least Malad 200 government schemes Malad delivered through these CSCs. Now Malad and Malad there are all over India there are Malad 5.4 lakhs village level entrepreneurs are working, and Malad out of which 4.35 lakhs are working through gram panchayat. Now Malad in West Bengal, if your lordship kindly turn to page 188, in 2015, the government of West Bengal partnered with the government of India for implementation of this national e-governance plan. Here the entire guidelines are there, and the charges which this VLE will charge, that is also specified in 2015. Now kindly turn to page 195. This is a communication between the Commissioner of Panchayat and Rural Development to all the district magistrate. Madam, may I just read brief because this is very important. You are aware that the Common Service Center scheme has been continuing in the state since last 2007 to 2008 for delivering different government, semi-government and other commercial services, list of services centers, though e-mode right at the doorstep of rural citizen at the nominal cost. From 2015, the Government of India upgraded the existing CSC scheme into CSC2 under the Digital India initiative. The CSC2 envisages the establishment of at least 2.5 lakh CSC covering all the gram panchayat in this country. As per the guidance of CSC and continuation from the Ministry of Electronics and Information Technology, it has been requested to co-locate the functional CSC nearest to the GP office premises so that the GP premises may be treated as a hub for the service delivery at the local level. To enable the co-location of CSC, a room approx 150 square foot with provision of electricity and internet connectivity is to be allocated. Regarding fixing of rent for the space allocated and other expenses, that is electricity bill, etc., Gram Panchayat authority may be permitted to negotiate with the CSC operator. The relocation may be completed within a month, and that is. Now, after this notification, the CSCs were relocated in the Gram Panchayat, and they are continuing with the implementing the schemes and services at the Panchayat level. Now, all of a sudden, at kindly turn to page number 201.
It was cancelled.
It was cancelled.
In 2020.
In 2020.
And they say Bangla Sahitya Kendra,
yes.
BSK.
BSK. At the very threshold, I say, I have no dispute with the BSK. Let the BSK be work. But at the same time, this CSC worker, there are twofold impact. Number one, the peoples are not getting the benefit of the CSC schemes. Number two, this 40,000 VLEs, they are jobless. Now,
no, what this page 201 says, West Bengal has been a pioneer state and so on, so on, so. In order to make the services available to every citizen at no cost, state government has set up the BSK all over the state. These kendras will be within the reach of people in rural as well as urban areas. Entire funded by the state government, no fee will be required to pay for availing the online services or for getting information. In view of so and so, stands cancelled. Accordingly, government will render all
Kindly consider the last paragraph.
Parastatal services through BSK info.
It is for the
no service shall be rendered through the common service center.
Yes. Now, this is for the service of the state government. the welfare scheme of the state government. It is always expected that a state government also render this welfare scheme through this online or e-mode. But at the same time, it can't be a nation within the nation. A state cannot deny to implement the scheme of the central government. And there are 200 schemes. The peoples of Bengal they are deprived from enjoying the scheme of the central government. At the same time, the 40,000, and I have searched with the website of BSK, there are perhaps 1,400 something BSK is now working. And there are 40,000 CSC workers. I want to narrate that due to the closure of the CSC, the impact. In 2000, after closure of this,
but this notification at page 201 says that all the facilities will be available in BSK.
BSK.
But where do you get it that the benefits of the CSC is not available in BSK?
Because this BSK is a scheme by the state government to render the welfare schemes of the state government to this Bangla Sahayata Kendra. And I have annexed the scheme of the CSK, which is around 200 scheme, and there are 29 banks are also connected with this CSK. And due to the non-functionality of the CSK, since 2020, there are 28 states of India as well as all the union territory able to complete their economic survey. Only the state of West Bengal, till date there is no economic survey in West Bengal, because this economic survey is conducted through the CSK. Now, in July 2023, the Ministry of Minority Affairs, Government of India, introduced the scholarship for minority students. Since there are some corruption on this particular scheme, the government decided to implement the scheme through biometric and with the help of the CSK. Lordship, kindly come to page
257.
257. Now, due to the non-functionality of this.
No, your issue is let the BSK function.
Yes.
That is in respect of state scheme.
State scheme.
But it does not take care of the central schemes.
Yes, madam. This is my case. And secondly,
why the writ petitioner should file a PIL? He can raise it in the assembly.
Something is need to be.
So he is there. He could have raised it in the assembly.
The parliament. In the parliament.
I'm sorry, in the parliament.
Now, the urgency in this matter is this scholarship scheme for the minority students.
3 years. So what's happening for the past 3 years?
We feel the necessity since all there are 33.
Where is the latest representation of the?
That is the last
280. Correct.
281.
280.
33 scholarship applications are there. Only 800 applications, biometric of only 800 applications are made. This is a time-bound matter. If this biometric through the CS is not completed, this students they are not getting the scholarship.
And who will appear for the state?
I've served,
Advocate General is here? No.
But I've served the government pleader.
I have got some submission in the.
But can you not enforce the scheme?
The government of India, with successive letters, directed the state government. That will, your lordship, will kindly find at page 223, 225, and 228 about the implementation of the scheme. 223, first. This is, my lord, written to from the concerned Ministry of Statistics and Programming Implementation to the Chief Secretary, then Chief Secretary. And then, my lord, the other one, the next one is another letter to the Chief Secretary, who is at present the Chief Secretary, and 228 and 227 and 228. My lord, may I just submit only one thing? Only
And what happened thereafter?
nothing. Now, when a scheme is introduced by notification by the government of India for making the government of India digital India, in our country a digital India, and my lord, 29 ministries of the government of India are functioning under this scheme, whether the state government within the constitutional setup can stop this scheme in clear violation of Article 256 and 257. These are directions issued to the state government under Article 257, 257. And in the event they do not comply, your lordships are, my lord, here to, my lord, ask them to complete. My lord, may I just read 256 and 257?
Before that, where is that CSC scheme?
My lord,
The preamble of the scheme.
my lord, I have a next, my lord, page 28 onward, my lord. 28A.
It will not includes the Digital India scheme, includes census also. The census, all other states are working on the census project, except the state of West Bengal.
There is also, my lord, a tele law.
And your representation has not evoked any response.
With my lord, jointly with NALSA, my lord, this CS6 scheme also, my lord, introduced a tele-law service, and 1,36,000 cases are registered, out of which 1,33,000 cases are disposed of. There are a panel of advocates who can, my lord, advise the litigant if, my lord, either.
In which paragraph of your representation have you said about this?
My lord,
your representation starts at page 280.
28.
Annexure PM.
My lord, page 21, paragraph 52.
In your
Representation, my lord, I have stated.
In your petition.
In my petition. One paragraph, please.
Page 2.
Paragraph 52, page 21 is, my lord, and my lord, the representation starts from page 280.
280. No, you are mentioning about this tele-law services.
Yes, yes.
Where have you said that, in your writ petition or in your representation?
Tele-law. Yes, my lord.
You said that it has partnered with NALSA.
Yes, my lord. Page 291. In our page 12 of the representation. Another aspect of CSC is that Department of Justice, Government of India has partnered with NALSA, the CSC e-governance service India Limited, for mainstreaming the legal aid to the marginalized communities through Common Service Center. The concept of tele-law is to facilitate the delivery of legal advice through a panel of lawyers stationed at the from the Office of the Legal Services Authority and CSC. The project initiates connect the citizens with the panel of lawyers through video conferencing telephone facility by the really identified 1 lakh Gram Panchayat. To achieve the digital India, there are other schemes. And in page, in our page 13, I have also given the figures that this is happened till 1,39,000 cases has disposed.
State government has been served.
Yes, I have given the affidavit of service. And if the CSC in function is, this number would be more.
All right, we'll call for the response.
Yes. Lord, and Lord, specifically the response
no, we'll pass a
regard
short
to the letters
no,
issued by the.
We'll pass a short order.
And my lord, only thing, my lord, I know, my lord, there is a very little scope for any interim order, but my lord, only thing, this minority scholarship is a very important factor because it's a time bound. If, my lord, it cannot, this biometric of this 36,000 minorities.
In which paragraph of your representation you speak about this minority scholarship?
My lord, in my representation, my lord, I have not pleaded the minority issue, but in my petition, my lord, I have annexed.
Where, which paragraph?
My lord. Kindly come to the paragraph 43, inner page 18 of my writ petition. The Ministry of Minority Affairs recently entrusted.
Para 43.
Page 18 of the writ petition, para 43, and also, my lord,
yes.
And my lord, page 253, my lord, find that this biometric can be done only by the CSC. Page 253, second paragraph. It was decided to conduct the exercise through Common Service Center. The ministry is now engaged CSC to conduct biometric authentication of INO, DNO, head of the institute, and the beneficiaries. The exercise is expected to take approximately 30 days. My lord, this exercise. Because well, there,
no, page 257 also, there is a one public notice.
Yes.
By this writ petition filed as a public interest litigation. The petitioner, a member of parliament, has, in our prima facie view, flagged very important issues concerning the welfare schemes promulgated by the central government. The scheme is called as CSC, all capitals. The CSC small e hyphen governance service India Limited is a special purpose vehicle incorporated under the Companies Act by the Ministry of Electronics and Information Technology. Full stop. CSEs, apostrophe S, are the, I'm taking from page 29. CSEs are the access points for delivery of various digital services to citizens mainly in rural India, thereby contributing to a digitally and financially inclusive society. Full stop. CSEs are enablers of community participation and collective action for engendering, ENGENDERING, social change through a bottom-up approach with key focus on rural citizens. Full stop. It provides a centralized collaborative framework for delivery of services to citizens through CSEs, besides ensuring systematic viability and sustainability of system. The CSEs are positioned as change agents, promoting rural entrepreneurship and building rural capacities and livelihoods. Full stop. CSEs are the access point for delivery of essential public utility services, social welfare schemes, healthcare, financial, education and agricultural services, apart from host of B2C, capital B, numerical 2C, services to citizens in rural and remote areas of the country. As could be seen from the scheme, there are as many as 14 category of services provided, apart from other services which are listed in the scheme. The category of schemes include agricultural services, health services, legal services, skill services, education, etc. The scheme so framed was implemented by the state of West Bengal. And in this regard, a resolution was adopted What is the date of the resolution? Page 188. Ah, yes. Resolution was adopted, which fructified into an order passed by the Government of West Bengal Information Technology and Electronics Department, dated 3/11/2015, pursuant to which the CSEs were established and made functional by locating them in the Gram Panchayat offices. This could be seen from the communication of the Commissioner of Panchayats and Rural Development Department, Government of West Bengal, to all the district magistrate, wide letter dated 2/7/2018. It is not clear. No, full stop. However, in the year 2020, the Government of West Bengal thought fit to set up a scheme called Bangla Sahitya, SAHAYATA Kendras, within bracket BSK, all over the state. And in the light of the same, rescinded/cancelled the earlier resolution dated 3/11/2015 and the order dated 15/2/2018, and directed that the Government of West Bengal will render all its public and parastatal STATAL services through the BSKs henceforth, and no service shall be rendered through CSEs/Tatya THYA Mitra Kendras, within bracket TMKs. It is thereafter several important persons in the society had been addressing the state government for restoring the CSE scheme, as otherwise the state of West Bengal would be left behind to be part of the digital India. The learned Additional Solicitor General pointed out to the letter sent by the Director General, within bracket ES, Ministry of Statistics and Program Implementation, Government of India, dated 7th March 2019, addressed to the Chief Secretary, Government of West Bengal.
Next one at page 227.
Pointing out as to the importance of the CSE e-governance services, and as to how it will facilitate in the objectives of facilitate in successfully achieving the objects of census. The writ petitioner has annexed various representations sent by the authorities. There is also a reference to a public notice regarding disbursement of scholarships under the scholarship schemes of the Ministry of Minority Affairs and National Scholarship Portal, which would require the applications to be processed through the CSE. There are other aspects also which have been, there are other notifications and literature which are annexed to the writ petition with regard to the various benefits of the CSE. Thus, seeking for proper implementation of the CSE, The petitioner has submitted a representation to the authorities of the state government on 16th August 2023, pointing out the importance of the scheme and seeking for its implementation. (56) he said. It is a submission of the learned additional Solicitor General that the state government is obliged to implement the scheme, the CSC in particular, taking note of the obligation of the state as stipulated in Article 256 of the Constitution of India, apart from the control of the Union over the state in certain cases enumerated in Article 257 of the Constitution of India. The petitioner would point out that the Ministry of Minority Affairs recently entrusted an evaluation study to the National Council of Applied Economics and Research, within bracket NCAER, to evaluate implementation of 3 scholarship schemes, that is pre-metric, post-metric, and merit cum means of the ministry. It is said that the findings of the study indicated gross irregularities with instances where benefit of scholarship schemes is not reaching the targeted beneficiaries. The report also highlights instances where unscrupulous elements have colluded with school/college authorities and have fraudulently siphoned off the scheme and entitlements. Another aspect which in our view would be of utmost significance is with regard to the partnership with the National Legal Services Authority of India, within bracket NALSA. This partnership is for mainstreaming legal aid to the marginalized communities through Common Service Center. Full stop. The concept of tele-law is to facilitate delivery of legal advice through a panel of lawyers stationed at the legal services authorities and CSC. And the project initiates to connect citizens with panel lawyers through video conferencing / telephone facilities. And it has identified 1 lakh Grama Panchayats. Further, it stated that to achieve digital India, inverted comma, digital India goal, the central government has started a project through CSC to give free primary computer knowledge to common people from the age of 14 to 60 years. But this has not been implemented in the state of West Bengal, thus depriving the rural citizens of the state from acquiring primary computer knowledge. The petitioner would state that in the state of West Bengal due to the absence of CSEs and for shadow and for the various programs, more particularly the tele-law program, is virtually ineffective. Further, it is submitted that the state of West Bengal does not provide any standard procedure similar to tele-law program as proposed and implemented by the Department of Justice, Government of India throughout the country. Thus, the petitioner's grievance is that the scheme, the implementation of CSE, which provides for social justice and for social welfare, is not being implemented in the state of West Bengal, which is a matter of great concern, and therefore prays for appropriate directions. After hearing the learned advocate for the petitioner and the learned additional solicitor general, it is not clear as to what are the services which are available in the BSK and what was the reason behind issuance of the notification dated 12/10/2020, stating that on and from the said date, all on and from the said date, Government of West Bengal will render all its public and parastatal services through BSK and no service shall be rendered through CSE. The notification dated 12/10/2020, if read as it is, more particularly the third paragraph, it, in our prime facie view, speaks of the schemes or services provided by the Government of West Bengal. And it appears that the services do not cover the schemes which are made available through the CSE or TMKs. Therefore, we direct the respondent state appropriate authority of the respondent state, namely the respondents 1 and 2, to state as to why a direction as sought for by the petitioner should not be issued to forthwith implement the CSE 2.0 in the state of West Bengal. The appropriate authority of the state respondent is directed to file an affidavit setting out affidavit in this regard. The concerned authority of the Government of India and other respondents are also at liberty to file their respective affidavits. List the matter.
My lord, in the midst of the judgment, I don't want to enter. My lord, I am applying for the state respondent. I've come later. My lord.
No, we just recorded that so that when you prepare your affidavit, it will be easier for you to answer this.
Lordship, I shall.
Lordships have made it returnable after
vacation. After puja vacation.
The affidavit to be filed by the state respondent shall also indicate as to what are the services and schemes which are implemented through BSK.
My lord, only thing regarding the minority scholarship, my lord, because this is the time.
We can't do any interim orders. You give a date in November.
Then my lord, kindly fix the matter before puja, my lord.
No, sorry, sir.
Before puja,
Next.
not possible.
Serial number 7.
I'm grateful, Your Lordship.
My lord, the matter returnable or my lord?
He will give you the date. Yes.
My lord, I am appearing for the petitioner. Actually, the service has not been completed. So
Alright.
maybe you can keep it for next week.
All right. List after service of notice on the respondent. Next.
Serial number 8.
Lord, I beg to appear for the question. This is the
Service complete?
yes, Lord. Service. It's going. And this stuck away. Service. Where is affidavit service?
Actually, item number 8, my lord, I am appealing on behalf of the state respondent.
Very
This is
good.
a matter, my lord, wherein the
My lord,
petitioner
I have sought for the instruction that has yet to come, my lord. So if your lordship kindly take up next week, my lord.
Can be disposed of. They have sought for consideration of representation.
No, underpass.
yes, my lord.
The problem is, sir,
My lord.
you are aware of lot of decisions of the Honorable Supreme Court.
Yes, my lord.
NHAA has been considered to be an expert body.
Correct.
So when these access roads are, there may be roads which have got a particular speed limit to be maintained. These roads, not access roads, these roads. The access point to the roads are also scientifically designed. Obviously, at times what happens, a village is cut into two.
Well,
it is cut into two. Normally, the people will take the cattle for grazing to the other side.
yes.
Their agricultural land will be on the other side. Residents will be in the other side. There is no way. They'll have to go 6 kilometers.
That is what is happening in this
Same matter. In fact, I was a party to a division bench which said, please make an underpass. Supreme Court reversed our order. They said it is up to the authorities to take decision. We can ask them to look into it.
Yes,
So there are various types of underpass. One is pedestrian underpass, which will be very narrow. You can take a two-wheeler or a cycle. Second is which will facilitate bullock carts, people to walk and bicycles. That will also be little wider where you can take a tractor. A tractor can be taken through the underpass. Then there's a regular underpass where buses, all heavy vehicles can ply. So we don't know at what is the distance between the one underpass and the proposed underpass you want.
Here, my lord, there is no even not even a service road, proper service road where the pedestrians can walk. My lord, we had sought for consideration of a representation that at least a pedestrian underpass will be constructed. But they are the appropriate authority who can take necessary instructions.
Now
Definitely.
the project director can take a decision. No.
But the NHAI is to answer, my lord. They have
Yes,
their
sir.
separate set of councils.
They have been served.
Yes, my lord. Everybody has.
Let them take note of your.
This can be directed to be considered and
Alpara More within Bhat
Nadia,
Jangla
Krishna
Gram.
Nadia.
Any map you have given?
Yes, my lord. Page 50.
50.
Yes, my lord. Page 50 is the map. But this is the Palpara mode. I'm sorry, my lord. This is a
Doesn't matter. And
the circle is the Palpara juncture, my lord. Here, my lord, if underpass, pedestrian underpass is constructed, but it will be beneficial for all of them, my lord. And the station is situated nearby, the district hospitals are situated nearby, my lord. But due to the non-availability of the underpass, not even an ambulance can go inside, my lord. They have to travel to 5 to 6 kilometers and turn around.
But what is the stage of the road now?
It is being constructed.
How long it has been there?
It has been there for quite some time. We have been making representations since 11th of January 2023, page 29 onwards. Is our representations.
But to cut open a road and make an underpass is.
It is not possible, practically not possible. At least an alternative arrangement be made so that the pedestrians of that area or the emergency vehicles can pass at least. Because there are citizens, there might be other.
Seems to be a very busy junction because the road, as we find, bifurcates. One leads towards Behrampur, Murshidabad, the other one towards Krishnanagar.
Krishnanagar.
Yes.
This is Behrampur.
Yes.
Krishnanagar. By this public interest litigation, the petitioner prays for appropriate direction to the official respondents to consider the representation which had been given to the authorities
Service of NHS.
On 4th August 2023, which was in fact a reminder to the earlier representation, which is in the nature of a mass petition signed by several persons, requesting for construction of an underpass in and around the Palpara Moor within Bhatjangla Gram Panchayat in National Highway number 12. Several features regarding the locality has been pointed out in the representation. And it is submitted that if an underpass is constructed, it will be beneficial to the local public as the area, namely the Palpara Junction, is a very busy locality, and it connects the two highways leading to Krishnanagar and Berhampur. This court is conscious of the fact that in a writ petition under Article 226 of the Constitution, the court is not court will not be inclined to issue any direction to the authorities, more particularly the National Highways Authority, to construct an underpass or a service road or a bridge, as it has been held in several decisions that the National Highways Authority of India is a technical body which will consider various issues before finalizing the alignment of a national highway, and also
My lord,
take note of
Mr. Anindo Lahiri, my lord, he has been, my lord, appointed as the special officer in so far as execution of this particular project is.
that stage will come later.
Yes. That road.
Also decide upon the access points to the national highway, bearing in mind various factors. Therefore, this court will not be justified in issuing any positive direction as sought for by the petitioner, more particularly when the highway has already been constructed and it is operational. However, since the petitioner has made a representation, the authorities, namely the National Highway authorities, can look into the representation and examine the feasibility of considering such representation. In the light of the above, without expressing any opinion on the merits of the contentions raised by the petitioner, we direct the respondents 3 and 4 to consider the petitioner's representation dated so and so 4/8/2023 and pass appropriate orders on merits and in accordance with law. In order to facilitate this direction, the petitioner is directed to send copies of the representation dated 4/8/2023, as also the copies of the earlier representations which have been given, along with a copy of the order, and forward the same to the respondents 3 and 4. The above direction shall be complied with as expeditiously as possible, preferably within a period of 12 weeks from the date of receipt of the copy of the representation. Next.
Serial number 9.
But he just intended to inform that the project is being undertaken on war footing by October.
The work which is going on, that should not be stopped for this consideration. That is my own.
That is the operation of the bowlers. Great.
9, my lord, I am for the petitioner, and this is against the, my lord, what has now become a policy of the state government to depute a WBCS officer as registrar of universities in derogation of, my lord, university statute or the government orders in this regard and the UGC, my lord, recommendations. But I say, my lord, kindly see page 25, the order. It was not a stopgap order or a, my lord, a tenure order for 3 months or something. And he has been usurping the post even though he is not eligible for the past 18 months.
But similar challenge was there earlier.
Similar challenge, my lord?
No, for the registrar.
similar challenge that is there at page 27, the order. That was by an aspiring candidate. That is different, but the Honorable Court.
No, before us, as a PIL.
We are not.
But this could have been a stopgap appointment, Malad. And he is, Malad, treating the university as an arm of the state government, Malad.
No. Now the page 27.
27
Binoy
is-
Kanta Sil.
Yes, that is in respect of another university.
Another university,
Yes.
not this university.
No.
Not this university.
There, the Honorable Court, Malad, intervened, and this gentleman actually could not even enter the university. My submission is that there are prescribed qualifications. He has to be a teacher. He has to have research experience. He has to have experience of deputy registrar for a certain number of years. A WBCS officer cannot possibly have those qualifications. And the intention is clear, Malad.
No, what is the material you have got regarding his qualification?
I have not, but he's a he cannot.
We are not a post office.
But I say that
please collect all information.
I've stated.
You collect. No. We cannot embark upon a fact-finding exercise on behalf of this professor Asit Kumar Basu. We are not here for that.
No.
Ask your
I've
Professor
stated
Basu.
on oath that
Ask Professor Basu to apply, get his credentials, then file a proper writ of quo warranto saying these are the regulations. This man's qualification is this. He doesn't do this, and we are here to collect data for you, issue notices. Then you will file supplementary affidavit.
I'll not do that. Well, kindly sees paragraph 12.
If you want, you withdraw.
Kindly sees paragraph 12. After that, I'll withdraw. I say that he has never occupied a teaching post.
He's
a WBCS.
No. All this ipsy dixie won't happen. As a public interest litigation, he is a professor. When you say that X is not qualified, you attack him in a proper manner. You get you suddenly one morning you wake up and you file a PIL and say issue notice, collect for documents. What are we here for?
I'll just place 2 lines and withdraw.
No. After some arguments, the learned advocate for the petitioner sought permission to withdraw this writ petition with liberty to approach the concerned authorities, collect appropriate information, and then proceed in accordance with law. Writ petition dismissed as withdrawn with liberty as sought for. Next.
The government will not disclose the information. The RTIs will.
You know how to get it. You advise. Probably he has not come to you earlier. You advise him now.
Oblige.
I put the petition. This state lordship.
I'm waiting for the respond number 4, man.
Okay.
Smooth functioning of the administrative tribunal.
The administrative
No,
tribunal act came into force, the 1980.
No. Now there are vacancies. Because whether I'll be search committee. I am part of the search committee. Initially, there was a search committee which was headed by our former Chief Justice, and the vacancy was circulated, and I think there was only one name, or they wanted a panel of names. Thereafter, that one person also got appointed to another tribunal. Then second meeting was convened, and it has been circulated. And I think it is in the process of the applications being collected. Probably by the next 2 or 3 weeks, recommendation can be made.
Malad, kindly see page 51, Malad. This is the notification, Malad, in terms of the order passed by the.
I've held 3 meetings. The committee consists of myself, the Chief Secretary, the Finance Secretary, the serving member of the tribunal, and one madam, I think she is Service Commission. She is chairman or not chairman?
One thing, Malad, the kindly. Was the order, otherwise, Malad, since 2000, Malad, 20.
Now what happened was, after this notification, there were only one application.
Yes.
Then after the cutoff time, another application came. You can guess who would be the person. Therefore, we couldn't take into account that. No. Initially, there were 2 applications. Then one came after the cutoff date. So what to do? So therefore, it should be a broad-based. And the third applicant beyond cutoff date was a very senior person recently. So therefore, once again, it has been circulated. I think some date we fixed for the meeting. I think it is in the last week of September that committee will meet. And I am confident it will be finalized. Then it is up to the state to pick up. Our job will be over.
Yes, I'm grateful for that. But
so you please wait for some time. Why a writ petition on this? It will be embarrassing for the applicants also. Suppose on the judicial side we take it out. If it is going to be sales tax tribunal, etc., is fine. Here, as per the qualification, should be should have been is a judge of the High Court or should have been a former judge of the High Court. There will be some embarrassment.
That's why the litigant at the suffering.
Suffering.
2020, they are waiting. Earlier version, the Honorable Justice Tendon was pleased to pass an order to direct into a single bench to pass the registry order without waiting for the division bench. But that could also not pass any order, simply giving the adjournment of the case.
But now there is a single member bench is available.
Single member is there.
He can decide.
No, he's cannot decide because they are waiting for the division bench. But that is the problem.
But he is an administrative member.
Administrative.
If he is a judicial member, he can.
Yes. That is why come before your lordship kindly.
No. In the judicial side, we can't do it. This is the problem. So far, I have held 3 meetings. This is Prakash Srivastava, Chief Justice, has held 1 meeting earlier. So something will happen. After some arguments, the learned advocate for the petitioner sought permission to withdraw the writ petition to renew the prayer by way of a fresh writ petition if a need arises. Writ petition dismissed as withdrawn with the aforementioned liberty. Next.
Serial number 11.
Grateful, Lordship.
Already upon. So that was application. Yes.
My lord, in this matter, I am praying for 1 week adjournment. My lord, I have served the copy upon the respondents, but till date, no copy of the application reached, my lord, upon the respondents, my lord, as per postal track report. My lord, I am praying 1 week adjournment, my lord. I have served, my lord, on 31st August.
You have to file affidavit of service.
Yes, my lord.
And why don't you inform the council for the railways? Who's the standing counsel for railways? The learned advocate for the petitioner is directed to serve papers on the learned standing counsel for the Eastern Railway. List the matter next week.
But Southeastern Railway.
Southeastern Railway. List next week in the same position.
Yes, my lord.
Today itself you serve notice.
Yes, my lord.
Next.
Grateful, my lord.
Serial number 12.
May it please your lordship. Matter is relating to Jadavpur, but this is an exceptional application, which I have filed it before their lordships. My first grievance is.
We will club this along with that 3 or 4 matters are there. Today in the newspaper we read that the students have agreed for installation of.
I'm not concerned about anything.
Then what are you
What is my
concerned?
grievance kindly causing for a moment. My first grievance is why the outsiders entered into the hostel premises.
That is why we have
given the permission.
That is why, sir, we have directed the student body to be implemented and they have to be served.
I appreciate it. Second,
Let it come along. When is it coming? Tomorrow.
And my lord, may I May I just trouble you, the Jadavpur University, as it is an autonomous body, my lord, that they has to be a party, my lord. They have not been implemented as a party, my lord. They are the. May I say one thing? Second grievance is UGC control over all the universities. Today is Jadavpur. 7 days before Bardhaman. 3 days before Gaurbango. What is administration is going on?
You please implead all the persons. You implead the student body also. Therefore, we can give compensative direction.
Internal
We have heard the petitioner appearing in person. The petitioner is directed to implead all the appropriate respondents against whom allegations have been made or directions are sought for. List the matter as soon as the application for impleading is filed. Next.
No.
You filed application, Will. Tomorrow you be here in the court. Next.
Serial number 13.
Lord, may it please your
My lord, I beg to appear on behalf of the state respondent.
Your Lordship, I am appearing on behalf of respondent number 1 and 2. Your Lordship, Siddhartha Banerjee is arguing in court number 5. I am seeking for a short passover, or can this matter be fixed
Second
at
half,
2
my lord,
p.m.?
I don't have any objection, but my lord, second half is original site, and my lord, by the impugned order in ad interim
Lordship,
stage, my
I am
lord,
strongly
restoration of possession has been granted. That is the only issue. If my lord grant me short protection and take up the matter day after tomorrow.
Your Lordship,
day
an
after
injunction was also granted in that interim impugned order.
Injunction restraining them from selling the property.
Yes. No.
him,
From
on-
us. Respondent
on him.
number 1 and 2.
My lord, kindly have the.
You should just show that paragraph.
Last page, my lord,
Your
I will
Lordship,
take you
kindly.
of happen. Lordship,
Paragraph number.
paragraph
Your
number.
Lordship, kindly come to paragraph
बोलते जाओ बाबा, আমি বলছি।
202, page number 200.
Lordship, since take paragraph 34.
Secure creditor shall
The secured creditor shall within 48 hours restore the possession of the secured asset taken pursuant to the aforementioned application under section 14 to the petitioners to be restored in its original form and status as it was when the possession was taken. The entire application under section 14 of the act and all actions taken thereupon, including all orders, is quashed and set aside as well in interim state. However, nothing in this order shall prevent the secured creditor to take further fresh step. Now, my lord, 37, the petitioner will be at liberty to make further application in the event occasion so arises for further interim orders with regard to property in dispute. The writ petitioner, however, shall be restrained from dealing with and or parting with possession and on encumbering or transferring the secured asset in any manner during the pendency of the writ petition in favor of the third party. So, injunction on them. Since certain other arguable points have been raised by the writ petitioner for hearing of the writ petition, the respondent shall file their affidavit in opposition 3 weeks from the date reply thereto, if any shall be such and such. The matter is shall be next listed on such and such. The question of maintainability of the writ petition is kept okay. So the issue is, my lord, other the point of my lord, alternative remedy and everything I have prepared.
May I indicate one thing, Your Lordship? Your Lordship, a writ petition was filed on last Monday. Your Lordship, subsequent to the filing of writ petition, they came and took the possession on the next day. Your Lordship, and Your Lordship,
but the thing is, only issue. The learned single bench has opined that there are arguable questions, number one. Secondly, the learned single bench has also said that the maintainability of the writ petition will be gone into. At this juncture, to issue virtually a mandatory direction to restore possession, what we can do is we can preserve status quo, whatever is there,
Your Lordship,
and probably request the learned single bench to see whether the writ petition can be
may I indicate
advanced.
May I indicate one small thing, Your Lordship? My right to do business is getting affected, Your Lordship.
What is the nature of the asset?
No, it's a it's not a residential, it's a commercial property. I have been carrying business over there.
You will be receiving rents. You will be receiving rents.
No. It is my commercial property.
Correct, sir.
I'm doing business over there.
Nobody is no. What are
they
you
have
going
the
to do with
possession. They
asset?
have the physical possession. From past 6 days, my office is completely shut down. My right to do business is getting affected.
I am not going to sell the property in near future.
But suppose he has got a running business.
I am running business.
Should he not be allowed to let for all purposes the possession stands vested with the NBFC
With me.
with the appellant. But can he be permitted to use the premises for running his office alone?
My lord, there is a problem. I tell you, Lordship, there is a complete distinction between symbolic possession and physical possession.
Yes, it
My
is.
lord, I have, my lord, in terms of following law, my lord, I have taken, my lord, physical possession of the property. Now, my lord, in the interim stage, my lord, without going into, as a matter of fact, I am relying also Lordship's judgment, whereby, my lord, partial order has been passed in a writ
We
petition.
can do one thing. If suppose they have filed their affidavit, we can request the learned single bench to take up the matter in the week commencing 25th.
Your Lordship, may I indicate one small thing? Your Lordship, section 14 order was passed on the basis of an incomplete application, which is also indicated
Therefore,
in the
that the
petition.
learned single bench will examine that.
But the possession, but the physical possession, but the physical,
The application is pending.
but physical possession is with the bank right now.
You manage for another 1 week or 10 days.
I'm incurring huge losses.
then
I'm incurring my
If
my
suppose the court.
my livelihood is
Correct,
getting
correct. We
affected.
fully appreciate, but then you're a defaulter.
But your Lordship, that needs to be proven first.
Procedurally, you may be right. Procedurally, you may be right in saying that it was an incomplete application. The district magistrate did not do this properly. This was a, you may even allege fraud.
Without jurisdiction also. The section 14 order was passed without jurisdiction.
So where do you challenge that?
There's a huge.
Yes.
Supreme
Yes,
Court
yes.
judgment is there. Well, may I comment?
I
I
said,
will
please.
finish. Well, I am ready with the judgments even.
Sure.
Even
No,
my
no,
lord,
no.
if
We are not going.
NBFC does not lie, my lord.
The
This is
correct, sir. The writ petition has been listed in October. We will request the learned single bench to get it in September. 20, the week starting 25th. Let the status quo remain for 1 week or 10 days. The issues are twofold. One is they raise a issue regarding maintainability. So the learned single bench has left the issue regarding maintainability open. Secondly, the learned single bench also records that there is an arguable case. So therefore, in the interregnum, of course, your junior friend said that after the writ petition was filed, possession was taken before the matter could be heard.
Overreaching the proceeding, my lord, of the court. My lord, kindly do not, my lord,
But
oversee
should
that.
he not challenge this before the debt recovery tribunal?
Yes, my lord, I have a very short answer to that. My lord, the law provides me 45 days time, my lord, to challenge any action from the date of the action. Here, my lord, I was, my lord, served upon the copy of the section 14 order very recently, only upon an application being submitted for certified copy. My lord, between the day I got the certified copy and the possession was taken, hardly, my lord, 4 or 5 days could, my lord, pass.
They are not required to wait. No, it is not something like
My lord, they are not required to hear me before passing section 14 order. But after section 14 is out.
They need not wait till 30 days. You have got time to file an appeal. In certain cases, the court will say that you will make the entire proceeding fait accompli. It is not so. It is like a judicial forum. So therefore, you please argue the maintainability issue, sir.
Milord, the
Because
may I, Milord, only say this. Milord, I am out, Milord, dispossessed of my property. Milord, without, Milord, having an opportunity to avail the statutory remedy even. Milord, the statute.
Even now you can do it. Even now you
Milord,
can do it.
after, Milord, implementation of the order, I can do it. I can ask for restoration.
Any measure under the act, under the whatever is the so any measure you can go. Even if you assuming it's a commercial property, 3 floors you are occupying, 2 floors are rented. Even the portion which is in occupation of a lessee, he is a third party to the proceeding. He can also approach. That's what
So there
Supreme
is no
Court says.
difficulty. Milord, if my lord kindly.
In fact, the remedy or relief you get before the debt recovery tribunal in such matters are far better than what we get.
Absolutely, my lord. There is no doubt of it.
As a matter of fact, they have also, my lord, availed the said statutory remedy.
They know how these people operate.
Milord,
They know better than us. Day in and day out, they know how these people operate, what sort of signatures they take. 400 signatures from you. Absolutely, you're kept in the dark. They paint a rosy picture. Tomorrow you'll become another Infosys, another this one.
Absolutely, that is exactly
they
what has
also
happened
started
here.
in a small shed with only 15,000 capital. One day you'll become a blue chip company. All good.
My lord, may I waste my lord's precious time for 2 minutes by the clock now? My lord, just to indicate, my lord, why, my lord, instead of going to DRT, my lord, I approached the High Court. My lord, I filed, my lord, a Section 17 application which is pending. That was against symbolic possession notice. My lord, very recently I came to learn that, my lord, after the symbolic possession, a Section 14 order has also been passed, my lord, on the basis of an application affirmed by a legal counsel.
That is what the learned judge has
Yes,
held in your.
my lord, one of a kind matter. My lord, a legal counsel can, my lord, within no stretch of imagination, be an authorized officer, my lord, of the bank who can be claimed to be in the helm of the administrative affairs of the bank. Then, my lord, my learned friend would be also, my lord, in the helm of the administrative affairs of the bank, my lord, because being, my lord, a senior counsel representing, my lord, the bank in court.
No, if
Now-
he is an officer who is receiving salary,
Then also,
why can he not? Apart from that,
well,
sir,
that is one.
this person is not as, what is a, he's an NBFC,
Well,
however it is maintainable.
Yes.
My
That
lord,
is the judgment of Supreme Court.
And even we have
Well, I have an
passed one
answer to-
interim order where State Bank of India was also there. Maybe it's purely contractual. There are so many clauses, etc. But there they were saying that declaring them as not a.
my lord, my lords know, my lord, the
NPA,
judgment of
something else.
Sagar Thamas by heart. My lords know, my lord, that judgment by heart. My lord, Sagar Thamas is the possibly the first judgment, my lord, in point of time, which say that, my lord, a writ petition against, my lord, a private bank would not be maintainable, provided, my lord, the bank, my lord, did not, my lord, commit any illegality in discharging a statutory duty. Here, my lord, the bank has acted, my lord, under a statute. So, Sagar Thomas was the first judgment of the Honorable Apex Court, my lord, in point of time on this, my lord, which has been followed
How
till
much
date.
is the outstanding?
2 crores.
2 crore.
2 crores.
My lord, they claim, my lord,
All right, 2 crores will be interest, penal interest, interest on
my lord, may I,
interest.
my lord, humbly pay for this?
No, see, the problem is you have admittedly you have borrowed.
Yes.
No,
Number two,
no dispute.
admittedly there is a default. 13.4 you have not challenged.
Yes, I have.
17 applications
Yes.
pending.
Yes.
So all points are open in that. But then is it prudent for the writ petitioner to fight with him or to mediate and draw a line? Probably you draw a line, your business was bad, COVID affected you, repayment schedule could not be adhered to. They can reschedule the loan, probably add on the interest, etc. You bring in some additional security. That will be a business module. Instead of dragging him to court, etc., then he becomes a pungent. He virtually is a partner in your business. But for his finances, how do you run the business?
My lord, a partner, my lord, who backstabs me, my lord, as of now.
But then at time you went to the partner, he didn't come to you. Probably,
May I,
business is solicitation. You accepted the
my lord, I fell into the trap.
solicitation. You went to
I
him.
fell into the trap.
Ah.
My lord, may I, my lord, pray for this much of indulgence? My lord, this was, my lord, my office. Correct? Now, my lord, if I lose my office, I lose my business. Does not, my lord, at the end of the day, help my learned friend's client either. If my lord kindly, my lord, allows us, my lord, to remain in the office for, my lord, at least a month. In the meantime, my lord, we'll try our luck before the learned debts recovery tribunal. My lord, if we fail in obtaining an interim order, we'll voluntarily make over the possession. My lord, that is, my lord, a fair suggestion.
But then what are you going to do with the property? You
It's
can't
a fair
sell.
suggestion.
There is
You now possession has been direct to be restored. He can't deal with the property.
Yes.
Huh? Now suppose we say maintain status quo. Where are you going to be?
status quo, I have already, may I?
But then in the interregnum, if you can't take steps to sell, what is the big prestige of holding on to the property? You don't get any single pie out of
May
it.
I respond? I have taken the position of the property after following due
We
process
will
of-
record that you are in lawful possession of the property. He will be a permissive occupant
For a
till
month.
the writ petition is
Then,
dismissed.
may I, I have to, then place. Lordship
I
sees,
can run my
he
case.
cannot, he has already approached the Debts Recovery Tribunal under Section 17. The application is pending. What he had
No,
to do.
therefore,
May I just 2 dates, 19th August 2023, we have intimated them by letter or the bailiff intimated them that we are going to take possession on 30th. So they had 11 days and an application pending before the Debts Recovery Tribunal. They waited for 11 days.
And just before possession, they, my lord, filed the writ petition. Now, my lord, after filing the writ petition, no copy was served on me. A copy on a different letterhead served on
Sir,
me. And he got this order when the writ
Banerjee,
petition is
one
not
thing
pending.
is, by an interim order, restitution has been ordered.
My lord, I can,
Tantamounts
my lord,
to,
I can follow that.
allowing the,
Kindly, my lord, allow me to run my business, to run the show. My lord,
that is
for a
what we
month.
will say, that whatever the status quo will prevail. Now already we are on the 4th of September. We will request the learned writ court to take it up in the week commencing 18th September.
Lordship, I am grateful.
By then you file your affidavit in opposition
Yes.
by this week.
My lord, I will. I will.
All right. We have heard the learned advocates for the parties. This is an inter-court appeal against an interim order passed. Interim order dated 31st August 2023 in WPA 21057 of 2023. The appellant, who was the respondent in the writ petition, is aggrieved by the direction issued by the learned single bench to restore possession of a immovable property which had been taken by the appellant pursuant to an order passed under section 14 of the Sarfasi Act. The learned single bench has also directed that the writ petitioner / respondent is not entitled to, is restrained. The learned single bench has also restrained the respondent writ petitioner from parting away the possession of the property or in any manner encumbering the property, any manner, full stop. The learned writ court, in paragraph 38 of the impugned order, has observed that arguable questions have been raised by the writ petitioner and opined that the writ petition has to be heard, for which the appellant respondents have to file their affidavit in opposition within a time frame. The matter has been directed to be listed in the combined monthly list of October 2023. The learned writ court has also left the question of maintainability of the writ petition open to be argued at the time of final hearing the writ petition. It is the submission of the appellant that when the appellant had raised the issue regarding maintainability of the writ petition, the same is required to be decided, and in the interregnum to restore possession of the property, possession of which has been taken by the appellant, would tantamount to allowing the tantamount to granting the main relief in the writ petition at an interlocutory stage. Considering the fact that the learned writ court has already observed that arguable points have been raised by the writ petitioner, and has also noted the issue regarding maintainability of the writ petition as argued by the appellant, we are of the view that ends of justice would be met if the writ petition is disposed of at an earlier stage. Full stop. We therefore direct the appellant to file their affidavit in opposition in the writ petition not later than 8th September 2023. Reply, if any, to be filed not later than 13th September 2023. We would request the learned single bench to take up the matter for consideration in the week commencing 18th September 2023. Till then, the status quo which is prevailing as on date, as on the date when the interim order was passed, that is on 31/8/2023, shall prevail.
Milord, may I prefer one small indulgence? Yes, Milord, my movables are, Milord, some movables
That
are,
we are agreeable to.
they are inside. Milord, I need those, Milord, emerging.
The learned advocate appearing for the respondent writ petitioner submitted that on account of the appellant taking actual physical possession of the secured asset, the respondent writ petitioner has not been has no access to certain movable articles such as computers,
Which are not hypothecated.
movable articles, which are not subject matter of any hypothecation.
Yes.
And they request that the said articles may be permitted to be removed by the respondent writ petitioner. The learned advocate appearing for the appellant does not have any serious objection to the same. for which purpose we direct the respondent writ petitioner to submit a request in writing um, by today, which shall be taken note of, and in the presence of an officer of the appellant, the articles which the movable articles of the respondent writ petitioner be permitted to be removed by tomorrow.
I'm grateful.
Great.
Much
Grateful. My lord, may this order be on the server, my lord, by today, subject to my lord's convenience, of course.
Definitely.
My lord.
We'll sign it too.
So grateful, my lordships.
Ordinance listed matter. Order seat number 1.
But I pay for the appellant.
Made, please, your lordship.
This is listed because we have decided one matter.
But this is entirely different, man.
It's not a covered matter.
No, it's not a covered matter.
It's not the related party thing.
But it's the same assessee. It's
Ah.
for a different assessment year. But
We'll have to hear.
yes, sir, lordship has to.
All right. The matter had been listed under the caption for orders. On a mention being made on behalf of the respondents that it is covered with the decision of this court in APOT number 187 of 2023, dated 30/8/2023. The learned senior advocate appearing for the appellant submitted, though the assessee is one and the same person, the facts are different and submissions have to be made. List the matter next week
Okay.
under the caption for admission.
Next Monday, my lord.
Anytime
Next Monday, my lord.
next Monday under the caption for admission.
Get full.
Mother, my junior says Wednesday. Next Wednesday week.
That will be 13th, is it?
13th.
Not the 13th, instead of the 20th.
20th. Very good.
20th. Yes, sir.
Yes.
Item number 2.
Well, I have concluded my submissions. Just 4 judgments, my lord, we have given them advance notice. Just your lordship may kindly take the reference and the paragraphs. I would not trouble to your lordship more than 2 minutes. This is with regard to that, so far the rule 3 is concerned that there is a no proper reason. Now, so far as my lord, my submissions that I have made, that the purpose of judicial review is to check whether the choice or decision is made lawfully. And not to check whether the choice or decision is valid. Or my lord, sound. Whether the reasons given are sound or not, it is not for the writ court to decide. So far, the second point is concerned whether the interpretation of a contract or breach thereof may not attract any arbitrary action. This is what 1991 letter, it's after all as a breaches or whether the parties are to act. The next a writ of mandamus does not lie to create or establish a legal right.
Correct.
It only to enforce a legal right which is already established. If there is no legal right, correspondingly, we also have no legal duty as a authority under Article 12. 4 judgments, to have.
You just give the citation. Paragraph number.
2007, volume 8, SCC.
Yes.
Page 212.
Paragraphs.
Paragraph 19, 20, and 24.
24.
This is in counter to the judgment relied by my learned senior adversary with regard to judgment reported in 1975, volume 3, SCC 503, where his submission was that it is nobody's case that the guidelines are without law and the administrative instructions, if can be ignored by the government. Here, in G. Ratnam case, the Honorable Supreme Court has, particularly to the extent these guidelines are concerned, and your lordship may recall 1975 was with regard to the service dispute. And this is only with regard to that if there is something infraction with any office memorandum or a guideline. Something to be done by departmental. This is not any service proceedings. This is extremely quasi-judiciary, which is subject to be reviewed by Section 9, which is a judicial officer of a high grade by district judge. So, in G. Ratnam, in para 19, 20, and 24, here, the Supreme Court, just one sentence I would read, later your lordships at my lord's wisdom, kindly read, according to my lord's convenience. Broadly speaking, the administrative rules, regulation, and instructions which have no statutory force do not give any legal right in favor of the aggrieved party and cannot be enforced in a court of law against the administration.
the executive orders, appropriately so-called, do not confer any legally enforceable right on any person and impose no legal obligation on the subordinate authority for whose guidelines they are issued. Their breach may expose the subordinate authority to disciplinary or other appropriate action, but they cannot be said to be in the nature of statutory rules having the force of law subject to jurisdiction of certiorari. But the rest paragraphs 19, 20 and 24, will kindly have a time to look. Then 2011 volume 15 Supreme Court cases, page 398. Here, my lord, the Honorable Supreme Court in paragraph 6, 7 and 12 has categorically held that if any executive instructions are to have the force of statutory rules, it must be shown they were issued either under the authority conferred on the central government or a state government or other authority by some statute or the constitution. Guidelines or executive instructions which are not statutory in character are not laws. The conclusion, my lord, this one sentence I would read for your lordship. I said 6, 7 and 12. 12, what is held in this case is that an unauthorized occupant or tenant against whom action is initiated under the Public Premises Act cannot resist the proceedings on the ground of non-compliance with the said guidelines. And I said, there is a caveat, there is not affluent and the commercial. And other two judgments, my lord, in Bharat Coking Coal Limited, reported in 2020, volume 16, page 759. Well, I have given the requisitions to my lord's officer to also to 2020, volume 16, Supreme Court cases, page 759. In case of Bharat Coking Coal Limited and others, my lord, I rely on the paragraphs 30 to 35 and 37. 30 to 35 and 37.
Yes.
This is, my lord, but merely because the acquisitions made are against the state or its instrumentalities does not mean an agreed person can bypass the established civil adjudicatory process and directly seek writ relief. In determining whether to exercise their discretion, the writ court ought not only confine themselves to the identity of the opposite party, but also to the nature of dispute and of the relief sought for. Now on 31, the most important part is, my lord, at so far as 31, the next page at 771. However, the writs are impermissible when the allegation is solely with regard to the violation of a contractual right or duty. Hence, the person seeking the writ relief must also actively satisfy the court. The right it is seeking is one of the public law and not merely contractual. And the operating part, the conclusion, on the contrary, para 35, we feel that the interest of the respondent number 1 was purely private and monetary in nature. 35, last sentence.
Yes. Yes.
And the last one is with regard to the Exide Industries, para 2020, volume 5, SCC, page 274. Para 21, 29 and 30. (21, 29 and 30). As per the settled principles of interpretation, a non-obstante clause assumes an overriding character against any other provisions of general application. it declares within the sphere allotted to it by the parliament. It shall not be controlled or overridden by any other provision unless specifically provided for. And this is with regard to the non-obstante clause and also the source and power of the parliament. Your lordship will find at paragraph 29 and 30. So far the disclosure and object and reason which have been held since Hari Singh onwards. And ultimately it is not their case, the parliament was not having enough power to this law. This is my submissions. Yeah. I'm grateful.
Yes, sir.
The 4 judgments, I have a copy, I can hand over also. Copy also. May I just have a copy of this judgment or lordship, these 4 judgments that I have shown?
We'll use the book OIVS.
Very. As my lords, please.
But today's emphasis on guidelines.
Yes.
Suppose there is no guidelines at all about the matter in that sense also. A action of an state under Article 12 of the Constitution must be fair, free from arbitrariness. For that, I don't need any guidelines, any authority. The opinion should be formed not arbitrarily. That was the point of arguing. Guidelines come to our help in this case, add strength to my argument because Supreme Court have construed these guidelines and have held the guidelines should have effect. Those judgments, Landed himself cited today 2011 Supreme Court cases. Can you see paragraph 12 of the judgment?
Anjan, 2011, 15 SEs.
Copy today. The 4 judgments that I've shown.
Book.
I have the copy. I have the copy.
All right.
So you are referring Ramchandra Pillai.
Paragraph 12, if I read, Lanu read up to paragraph 11. Good. We may paragraph 12, page 4 and 2. We may, however, add that this order should not be construed as laying down any proposition that public sector undertakings and financial institutions to whom the guidelines were addressed could willfully ignore or violate the same. Whenever any action is proposed to be taken under the Public Premises Act, authorities concerned are bound to keep the said guidelines in view to the extent possible on the facts and circumstances of the respective case. If any public sector undertaking or financial institutions is of the view that any of the guidelines are contrary to the provisions of the Act or otherwise unworkable or impracticable, they can also seek modification of the guidelines or have their own internal guidelines. They have to seek modification guidelines or internal guidelines. What is held in this case is that an unauthorized occupant or tenant against whom action is initiated under Public Premises Act cannot resist the proceeding on the ground of non-compliance with the guidelines. Because the guidelines no application in this case. What ground eviction was sought? Can you see? Building, rebuilding, reconstruction. With a valid ground under any Tenancy Act. Can you see the ground? Kindly come to paragraph 8. In this case, the Ramakrishna Pillai was in occupation of the shop in 1961 when the premises were purchased, and they continued in such occupation and paid the rent regularly till 1997. The bank issued notice of 5th February 1998 demanding him to vacate the premises as it required the property for demolition and reconstruction for his own use. It's grounded in everywhere. Every tenant act provides for that. Similarly, not a ground with an arbitrary ground. I'll come to this, but I'll show the guide. Why refer to the guidelines given by the Income Tax Department or the Vigilance Manual in a public inquiry when we have got Supreme Court judgment to guide us on the guidelines? Particularly in this case, I'll come to this while dealing with their case. There have been judgment have been cited by learned friend. I have cited judgment. I have dealt with the judgment cited today. That's what I am only entitled to. They have cited judgment for the proposition that the Tenancy Acts, to the extent they are repugnant with the PP Act, Public Premises Act, do not apply to public premises. That's the law. Tenancy Act, to the extent it is repugnant to the Public Premises Act, would not it would not apply to a case under Public Premises Act. I admit that. No problem about it. I've never argued to the contrary. That's why Supreme Court laid down in the matter of standardization of rent, revision of rent tax still applies. And they have to obtain the rent revision as per the law. Guidelines also provide the same thing. You get revision of rent as per the law. That is the paragraph show that. For this Miller proposition, what I say, yes, existence of power is one thing, very important. It affects the jurisdiction. If there is no existence of power, affects jurisdiction. But if there is in existence power, that gives the jurisdiction to act. And jurisdiction given to whom? Not to a private party, but to authority under Article 12. Now, next question is, while exercising your jurisdiction, can any authority, state or authority under Article 12, act arbitrarily? That's the main question here. To all these judgments regarding jurisdiction, I shall deal with them one by one and show they will help me to. And it is established that when an authority has an authority under Article 12, have the jurisdiction, then they have to exercise the jurisdiction and power in a fair and reasonable manner. And they cannot act arbitrarily. Next, also find the guidelines. Start with the expression 2002 guidelines to prevent arbitrary exercise of power. Why? The Supreme Court further held in the Kosaka case, that this power under under Public Premises Act is a very drastic power. And that power should be exercised. Challenge was thrown when the constitutional validity question arose, that if you allow this power, then this bank or other LIC, etc., they will purchase tenanted properties at a low rate, at low price, and thereafter, by use of Public Premises Act, they will evict them one by one, just terminate tenancy and evict them. That question raised before Supreme Court. And Supreme Court also a marketing case, constitutional validity, the constitution bench held. We uphold this on the basis that this power will be exercised by the authority under Article 12 reasonably fairly and as a model landlord. I'll come to that when it comes. Now, may I start dealing with the judgments one by one?
Yes.
2011, volume 13, SCC, Supreme Court 446, learned friend relied on this judgment and paragraph 96 of this judgment. Now, my boyta আছে? Okay, what could you do? Yeah.
Which judgment? 2011.
Lord, you will find me, Lord, from this judgment itself.
13 is this, yeah?
No, too many copy. No, don't give our. My lords have already got copy. They might have marked them. The my lord may have marked. If you give a fresh copy, then they have cited the judgment. They have given the copies. It would be desirable if you give those copies. The my lord may have marked. This might help you, Lordship. Lordship may have marked some portions of this judgment. আমাদের judgment কোন document দেবে?
Yes.
Now, this judgment has got two things. Two summary of law. Kindly see paragraph 48, one summary of law. I'll not trouble you to enter details. Paragraph 48, there's summary of law. 48.1. Before we deal with the rival contentions, submissions on the maintenance of standard rent application, it was not a case for eviction. It was a case for fixation or revision of rent. We may note that with respect from the public premises, it is now well settled that Public Premises Act shall apply and not the Bombay Rent Act will apply. That is not good. 8.48.1, Lord kindly see, with Daniel Friend says, which is in Kaiser Hind, that judgment cited by him, by Daniel Friend. One of the questions we have the constitutional bench was whether the provision of the Bombay Rent Act having reenacted and simply one statute, etc., will prevail over the public premises. No dispute. Rent Act is superseded. This is 48.1 and 48.2. Between the Public Premises Act and the MRC Act, among others, to Rent Act, this court held in Crawford Bailey that to the extent specific provisions were made to public premises for eviction or unauthorized occupation, that act will apply with respect to the premises of State Bank of India, which are in dispute, that the matter not MRC Act and not MRC Act. With these 2 points, I have no dispute. The rent act will prevail. Next paragraph will have relied upon another summary of law, paragraph 98, I think. Yeah. The 96 of it.
They referred to para 96 on the effect of guidelines.
Kindly come relate to paragraph 96, my land relied upon. Please see and then come to summary of law. I am just in mind paragraph 96. We may now also note this a subsequent clarificatory order dated. This is very important. I am relying upon. Central government has made it clear that guidelines dated 2002 will not apply to affluent tenants. Then governments relying on the guidelines to exclude the operation of the guideline, a corrigendum guideline is being relied upon. See the significance. Guidelines are being relied upon to exclude the another guidelines. We are admitting.
But I think that was an alternate submission. He said, first of all, guideline is not applicable, etc. No statutory force. Assuming so, it is not applicable to affluent tenants and commercial property. That was alternate submission. I think.
Alternative, but it is not, I mean, Supreme Court can be similar, it is alternative to what? That Supreme Court as it meant.
No, if they want to refer to this, obviously it means that the guidelines are binding.
And Supreme Court using as an alternative submission is applicable. Can you see me, Lord? They are following the line, the guidance quoted. Then, after quoting it, the quoting is the guidelines are meant for genuine and non-affluent tenants, and they are not applicable to the large business houses, commercial enterprises. It is guideline, but it is not alternative case is being made on what basis? That these guidelines do apply. But even if apply, it is exempted by another guideline, a later date. Then, so these cases, they don't militate against the principle that guidelines are to be considered. Not a statute, I'm not saying that, to be considered. They're not just waste paper basket. This is the only thing the other judgments are there. Guidelines are applicable to be considered. Paragraph 12, I've just now read to your lordship. Paragraph 12 of the 2011, volume 5 Supreme Court case. So they have cited. 11, volume 15 Supreme Court cases. Paragraph 12 lordship read. After lordship did this, they not kindly simple another paragraph. Summary of law is there. I do not think is relevant. That is not caricature. Nothing. They have not relied upon it either. So, my lord, the two judgments they have cited today, one very expressly says 2011 volume 15 Supreme Court cases just now cited, paragraph 12. Guidelines are important factors, and they have to ask for modification if the guideline is not applicable. Now, this judgment relying upon for the proposition, as I already indicated, that guideline is attracted by Supreme Court. Next judgment they have cited 2014 volume 13 Supreme Court cases, 291. This was judgment passed on a contempt petition. Can you see it first? Judgment now, just filed in a contempt petition. Here, the profile case was explained on a contempt petition.
Yes, sir.
And I humbly beloved here, I like to make some correction also on my part. May kindly come to this explanation given by same learned judge, Justice Gokhale. What he says, his profile case, he was misunderstood according to him. What he said, this is really important. He said, profile case, we have laid down that as long as the protective umbrella of an welfare legislation subsists, this PPI cannot be applied to override that. This is provision, right or wrong. This is wrong. But once it is removed, once the welfare legislation umbrella is removed, then Public Service Act will apply. Similar how he has dealt with it. And that's I show that paragraph. And in view of that, I have to admit that in this case, I cannot rely on profile case, which I have done. No, but after considering his own explanation, because why? In this case, the notice to quit was issued after the protective umbrella of 1956 West Bengal Privacy Tenancy Act was removed. That act was repealed with effect from 2001 by 1997 Act. And notice to quit in this case was issued after that. So, my lord, I have argued, but on a second thought, and upon considering all the judgment, I have to submit that in this case, I cannot take advantage of the profile case. Because the notice was issued, eviction proceeding was started after the protective umbrella of 1956 Tenancy Act was revoked. When the PP Act came into force, my client was enjoying 1956 Protective Act. That act was applicable to LIC, 56 Act. So the idea is কোথায় গেল? 14 volume 30. Volume 13 SCC 291. Volume 13 but 2014 volume 13. Itu exercise 291 van box. আচ্ছা এইটাই হবে তাহলে। That may clarify, my lord, what I said. 1956 Tenancy Act applied to LIC.
Yes.
Though no exemption in case of statutory corporation. And that contained protection of tenant, and my client was covered by that act, rain being so much and etc. That act was repealed in the year 1997 with effect from 2001, some date and that 1997 Tenancy Act took out exempted statutory corporations. And LIC became statutory corporation. That is why, my lord, it was not available. I have made that argument, my lord, so I am correcting myself and telling lordship that I rather should withdraw that submission. Now, in this judgment, my lord, Justice Gokhale has explained. কোথায় 2000 তোমার সাইড করলে 2000 এটা সাইড করছো 14 ভলিউম 13 এসসিসি সাইড করেছিলে 2014 ভলিউম 13 এসসিসি হ্যাঁ হ্যাঁ আমি কাছে দেই তোমার কপিটা করে দাও এটা পাচ্ছি না এটা 291 they have cited you have cited
Which one, sir?
they have cited each other.
This is with regard to the other judgment of Justice Gokhale in Central Bank of India, 2014.
Yes, they have said.
And both of these judgment along with Jain Inc. was considered by Justice Datta that I have shown to the
That
Lordship.
part of consideration may be out of my lord's mind. I have to shorten this. I have to admit something. These judgments clarified that. Well, I'm therefore saying that, but no question in this judgment, no question of formation of opinion or on a reasonable basis or bona fide termination of tenancy was considered. None of these cases. But I'm making clear, I have made submission, but now my submission remains, yes, the act, even if the act applies, the act applies, authority has to act bona fide and not in arbitrary manner. This is the argument now. Argument now. Now let us see whether they have cited any judgment that when the Public Premises Act applies, the authority under Article 12 need not act reasonably or fairly. That is the point now. And that is why I submitted that requirement of formation of opinion under the rules. And I placed that opinion with the grounds for formation of opinion. Your guidelines are not necessary for me to say. I will come to guidelines who will buttress my submission later on.
Yes.
I'm not dealing with a private landlord. Now, next judgment is, Milord, 2002, volume 8, SCC, the Kaiser Hind judgment, Milord. That is already considered in other cases. Milord, to the extent of repugnancy, Tenancy Act surrenders. 254 article. I'm dealing with that, is nothing to do with that. Then, Milord, 1980, volume 4 Supreme Court cases, Jain in case 435. This is a judgment, patient. This is a judgment for the proposition, again, that the Tenancy Act is overridden or superseded by Public Premises Act. I don't dispute that. Don't dispute at all. And not that their question arose that although Premises Act 1971 was actually passed on 23rd August 1971, it was given effect from 1958. This judgment is for that proposition, although it gave a retrospective effect, it overrides West Bengal Premises Tenancy Act 1956 or PP Act compared with Tenant Rent Act, Special Act, and therefore it will override Special Act. Special Act is a Transfer Property Act is a central act. That is not state act. That is not overridden by another the Public Premises Act. That is clear. 1964 Supreme Court 377. I in my humble servant no 37 paragraph 5. It is no application in this case. That was the case for the proposition that if a statement of fact is made in the judgment by a learned judge, it cannot be challenged unless court admits it. I have not said the learned judge has noted my argument, our argument wrongly or anything. I don't say any application. No. There's no application. 93 Supreme Court 377. When a statement of fact made in a judgment can be doubted by the appeal court. But the statement of fact, not statement of law. Statement of fact. I'm not disputing anything. Statement of law. Statement of law is always disputed in the appeal court. But that is judgment. Statement of fact, different thing. Then he relied upon 2019, volume 1, Calcutta High Court notes. Paragraph 5. In this case, can you see this judgment, Milord? In this case, eviction notice was given, not on arbitrary ground, or not on non-existent ground, but on the ground of subletting. And user of the premises change of user of the premises. Paragraph 5. It's not a case of arbitrary or exercise of power under our public premises. Paragraph 5, can you see? that he had relied upon. Yes. Paragraph 5, change of subletting and change of use. Nobody's argued that the ground for eviction was arbitrary or unreasonable. Now, Miller, now come back to the judgment, the first cited, the first date.
Yes.
This is Miller, I take chronological order. 1972, volume 2, SCC 239. What is it? 1972, volume 2, Supreme Court cases 239. He relied on paragraph 10. That is a long judgment, Lord. I tell you what the issue about. In this case, question was whether the Public Premises Act 1971, insofar as it purports to validate the 1958 Act or things done under 1958 Act with retrospective effect, is it valid? Whether 1971 Act has got twofold character. One is a positive enactment and also as a validating act. It validates acts, 71 Act validates things done under 1958 Act, which was held to be Aslavari's Article 14. Article 14. And what ground it was so held? 1958 Act gave the authority two alternative options. The authority could file a civil suit and also may also go public. That is why. And that is why, my lord, 1971 Act removed that basic ground, namely filing of suit or proceeding under general law of the land, civil court was taken away. So option was taken away, it no longer invalid. But the question was whether it validating the things done under 58 Act, which was ultraviolent and void, are valid. The Supreme Court says if the act is valid, you can validate acts. That on that point, validity of it doesn't consider validity of 1971 Act as a whole. It considers the second aspect of 1971 regarding validity. Now, validity of the 1971 Act as a whole came into consideration in 1994, the Ashoka marketing case. That should come to that. Can you see the next judgment? Learned friend cited. 1994, Supplement 3, SCC 694. Kindly have this judgment, a very unusual judgment. I will take 5 minutes my last time to clarify this judgment. Very unusual judgment. আমার বইটা দাও আমার বইটা আছে না আসেনি ওর বই আছে তোমার থেকে দাও Paragraph 3 of the judgment, can you read? That was the basis of this judgment. This is based on Jiban Das, but the Life Insurance Corporation. That's the K. Ramaswamy. May I kindly come to the basis of the judgment is Ashoka marketing, the Constitution bench. Kindly similar paragraph 3 of this judgment. Ashoka marketing judgment. Similar contention on the unveil of Article 14 of the Constitution was raised on the ground that when the Delhi Rent Control Act provides remedy for ejectment on specific grounds and fixity of tenancy rights, giving blanket power to the public authorities under the Act, is violative Article 14. Then in Ashoka Marketing Limited, this court by a Constitution bench in a slightly different connotation dealt with a similar contention in paragraphs, my calendar marks 60 and 69. 69 paragraph is very important of the judgment. and held that the scope of provisions of Public Premises Act cannot be cut down on the basis of apprehension that the corporation like the nationalized banks or LIC, which are trading corporations and cannot be, is not kindly mark the word prescribed, is not prescribed. Is not what misquoting in the judgment. Is not prescribed. It is, I'll come to that, kindly mark the word prescribed, and then another very serious misprint here. From buying the property, prescribed, buying the, it doesn't make sense also. From buying the property in possession of the tenants at a low price, and then evicting the tenants after terminating a tenancy and selling the property at a much higher value, because the value of the property in possession of tenant is much less as compared to a vacant property. The consequence of giving overriding effect to the provisions of the Public Premises Act is that the premises belonging to companies, statutory bodies referred to in clauses 2(c) section 2 of Public Premises Act would be exempted from the provisions of the Rent Act, then Control Act. Action of these companies and statutory bodies while dealing with the properties and the Public Premises Act will, is kindly mark the word not. Not is not there. Will not have to be judged by the standard, they would not act as a private public limited. See, madam, the entire judgment is based that the challenge is thrown that this you giving such exorbitant power is to be exercised by the authorities to buy the properties at low price, the rented properties, and then the action of these companies and statutory bodies while dealing with the properties under the Public Premises Act will not have to be judged. It explains will have to be judged. Not is a mistake. And the meaning is changed. Have to be judged by the standard that they would not act as private individuals. This is paragraph 69 referred to. Can now see paragraph 69. It's very unusual because it is a Supreme Court misquoting, and on that basis, basing the judgment. Please come to me, Lord, Osaka Marketing.
1994 SEC.
1990, volume 4, Supreme Court cases. এখান থেকে এটা বার করে দাও দেখি এই জাজমেন্টের একটা কপি একটা নাম বার করে দাও তো এই জাজমেন্টের একটা কপি Let it make the entire complexion change. Paragraph 69 please see. পেয়েছে হ্যাঁ আচ্ছা মনে হয় কপি আছে দিয়ে তো
I have copy if Lordship.
I have got a copy. One copy from my side, one copy from you.
Very well.
Both. Dwarkada's Manfatia has been quoted here. Both of you, Lordship, got it?
Yes.
Paragraph 69, page 446. Page 446. It has been urged by the learned counsel for the petitioners that many of the corporations referred to in subsequent Public Premises Act, like the nationalized banks, LIC, are trading corporations, and under the provisions of the enactments whereby they are constituted, these corporations are required to carry on their business with a view to earn profit. You have seen that, Mila? For profit. And that there is nothing to preclude these corporations to buy property in possession of the tenants at a low price, and after buying such property, evict the tenants after terminating a tenancy, and thereafter sell the said property at a much higher price, higher value, because the value of the property in possession of a tenant is much less as compared to the vacant property. This is a challenge. How they are upholding, this is very important. We are unable to cut down the scope of provisions of Public Premises Act on the basis of such an apprehension, because, as pointed out by this court in Dwarkada's Manfatia's case, every activity of a public authority, especially in the background of assumption on which such authority enjoys immunity from the rigors of Rent Act, must be informed by reasons. This is what I am relying on, informed reasons, and guided by public interest. All exercise of discretion or power by public authorities as the respondent in respect of dealing with the tenants, in respect of which they have been treated separately and distinctly from other landlords on the assumption they would not act as private landlord, must be judged by the standards, by that standard. No prescription is not there. Then these observations were made in the context of provisions of Bombay Rent Hold Act, whereby exemption from the Provisions Act has been granted to the premises belonging to the Bombay Port Trust. The consequence of giving overriding effect to the provisions of Public Premises Act is that premises belonging to companies, statutory bodies, referred to in clause such and such of the Public Premises Act, would be exempted from provisions of Rent Act. The action of the companies and statutory bodies mentioned in clause 2 and 3 of section of the Act, while dealing with their property under the Act, will therefore have to be judged by the same standard. Not. The word not is not there. Have to be judged by the same standard. The 1994 supplement. This prescribe is preclude. What is preclude? Can we come to page paragraph 69? There is nothing to preclude. The B and between B and C. Placidum B and C in between. Upon required carry on business with a view to earn profits. And there is nothing to preclude. Nothing to prescribe is not there. Cannot be prescribed from buying. They cannot be precluded from buying. That was the thing, argument. And the note is not there. Is the other way around. It's the other way around. Act will have to be judged by the standard that they cannot act. Will have to be judged by the same standard. And that was the reason for upholding the validity of the Act. Can you read on paragraph 70? Copy আছে direct. Direct workers Manfatiya. একটা brain copy আছে. একটা judgment copy আছে. That now kindly see paragraph 70. For the reason aforesaid, the constitutional bench is holding. We are unable to accept the contention. Landed council petitioner, the provisions contained in Public Premises Act cannot be applied to premises which following evident. So that was on the basis that we will act fairly, reasonably, and not arbitrarily. Now, this is the provision Act has been, the court which is upholding the Validity Act is upholding on this basis. And how can anybody say now that they're free to act any manner they like? So, this is the first judgment which lay down in my humble submission very categorically that while exercising the draconian power, question is whether apply this 10 premises act or not, they have to act fairly reasonably. And number two, Dwarkada's Matfati applies and the public authorities, Article 12 authorities should act as a model landlord, fair landlord, not like a private landlord. Now, this is the two things I am humbly submitted. That let us see, my lord, what no judgment has been cited. Guidelines, my lord, is creating a cobweb of confusion. Guidelines say, buttress this. Central government realized that. And my lord, the guidelines start with the word, there are several guidelines. The guidelines have started the word as observed by Ashoka Marketing in the judgment. We are giving these guidelines so that arbitrary exercise of power may be excluded. The guidelines work out in the guidelines. And how many times Supreme Court has said this? Let us see that this must be act not arbitrarily and unreasonably. That I've already indicated, I have not relying on profile case for excluding jurisdiction. That is, but rely on the other part of profile case, that is, or Millard, let us say not profile case I'm relying on. I mean, Bantawala's case, just tabulating, Millard, what court has said so. Apart from Ashoka Marketing, Bantawala's case, 2011, volume 13, SCC, 446, paragraph 92.
That one.
And paragraph 95, to prevent arbitrariness, these guidelines have been given. 2011, volume 13, Supreme Court cases, 446.
That you know.
I am relying on that. Next, 2008, volume 3, Supreme Court cases, 279. What is these guidelines have been explained? What is the effect of these guidelines explained in paragraph 22, 36 and 41. If my lord, can you allow me to read that portion? Kindly read that. What is the guideline effect? Paragraph 22, heading guidelines. Is Public Premises Act. Heading is guidelines. Judgment. You have cited this case in the trial court. You have cited. A tenant of a public premises, although ordinarily does not get any protection from the eviction from the tenanted premises under the provisions of Maharashtra Rent Control Act, it is accepted the action on the part of landlord, which is a state, within the meaning of Article 12 of the Constitution of India, must in this behalf be fair and reasonable. In other words, the action of the state in terms of provisions of the Act, this Public Premises Act, should not be arbitrary, unreasonable, or manner finding. With that end in view only, and for determining the legal effect arising thereunder, central government had from time to time issued several guidelines. Guidelines so issued, all the guidelines referred to here below. So for that purpose, when the Supreme Court laid down why these guidelines are issued, why should it refer to the vigilance manual? There is no scope for referring to vigilance manuals or Income Tax Act. Clearly saying what is the object of these guidelines? To prevent, with that end in view, acting, determining legal effect at guideline made. In terms of state guidelines, however, a distinction is sought to be made between a tenant who is rich and industrialist, see, and a person who is poor and uses the technical tenanted premises only for his residence, as would appear from Gali Exodus. Now, this has been further is not controlled by statutory provisions. The next paragraph says it is not controlled by statutory provisions. Guidelines are not for statutory provisions. Then not after appreciating this will be paragraph 36 kindly come to concept of what is meant by concept of fairness for Article 2 of landlord. Paragraph 36 to Millard, paragraph 41. The concept of fairness while acting under Public Act. The procedural aspect of who lead evidence were then 37. Thus, under Public Premises Act, occasion arise for multi-level inquiry, primarily to conclude on action. Question has been succinctly dealt by division Bombay High Court case is quoted. Just 3 lines I'm reading. The government, company or corporation must so act not only when terminating the authority of an occupant of public premises of its ownership to occupy the same, but also when thereafter it seeks its eviction therefrom. So when they decide to terminate under 106 of Transfer Property Act, they must act fairly and reasonably. The statute, although does not require a lengthy hearing or etc., causing etc., and must be given opportunity to effectively show cause. For the said purpose, paragraph 40 minute now can you see. For the said purpose, section 4 and 5 of the Act must be read together. Even the rules which are validly framed must be read along with the statutory provisions. Ordinarily, although a tenant occupying the property belonging to a government may be somewhat in a worse position than a tenant having protection of the Rent Act, as has been held by full bench of Calcutta High Court in such case, but with a view to interpret the provisions of the Act, we must take into consideration a decision of this court, laying down concept of bona fide act and the fairness on the part of the owner, as laid down in Dwarkadas Manfatia and Sons as the Board of Trustees. And Osaka Marketing Limited and Osaka Marketing, all these judgments relied upon. No. The court court. Dwarkata Market again quoted. The public authorities which enjoy this benefit without being hidebound by the requirement of Rent Act must act for public benefit. Hence, to that extent that is liable to be gone into and can be subject matter of use. They are applied. Market applied in the Osaka Marketing below. Paragraph 69, which I have read. I don't, it's applied. Paragraph was noted by the Constitution bench.
State officer directed the business want to lead this. Process not filed an application to obtain to vary this often direct the lead evidence.
11 volume 15 years.
Yes.
Yeah. So it is a constitutional protection given. Now let us see. Today my learned friend cited the judgment 2011 volume 15 Supreme Court cases 398. That will not apart from paragraph 12. This judgment also says they cannot die arbitrarily.
That we have not.
Section itself, that provision paragraph is there. Then not 19. Now today he has cited 4 new judgments. Let us see what the judgment. Do they militate against what I have submitted? That in this case, opinion to terminate the tendency of the writ petitioner was not formed bona fide and reasonable manner. Number 1. Admittedly, my client has been bona fide tenant and tenancy was terminated on ground which are non-existent. Non-existent. I'll show you, Lordship, the ground today. Now, let us see the cases they have cited. 2007, volume 8 STC, 212. What are they? Take a look. Take a look. 2007, volume 8 STC. Take a look. After judgment site,
Start with this. We concludes. What on meeting?
I got it. This is a proceeding for departmental. Oh.
Except this part of matter, all other matters are released for the day.
You will?
All other matters are released for the day.
Oh, really? I'll finish.
I got a meeting at 4 o'clock.
Oh, I
Yeah.
see. Okay,
No, we'll hear you.
May I just deal with the 4 judgments? And
Yes.
this is a case, my lord. A vigilance manual was there. That was made equal to departmental instructions.
Yes.
Now, proceedings of the departmental inquiry, it was held to be procedural. Paragraph 24 of the judgment, it was held to be procedural, not of any substance, not substantive. Paragraph 24. Fact was, on a decoy, this ticket collector was caught red-handed and he was found to be. But the vigilance inquiry of officer found that all everything is proved that he was caught red-handed and proved. But some vigilance manual was deviated from. That is not substantial. That is procedural. Therefore, it is bad. But this is not vigilance manual. My husband, why going to that when Supreme Court has interpreted the guidelines which are involved? Why should you go into that? Next judgment is cited today.
2011-15 SEC.
20. What about what?
No,
yes, that's just now dealt with.
No,
that I dealt with.
Actually, the 3 remaining judgments was executive institution, no statutory force.
No statutory.
That is your senior has
No
dealt
statutory
with.
force, nothing.
Then writ is not the remedy. That was one judgment. And objects and reasons behind the LIC Act has to be seen.
See the LIC.
Because public money, that's
objects can we see? It is objects and reasons.
We will deal with the legal issues. If both of you want, you can put in a small written note.
Correct.
If you
objects and reasons, my lord, are to the nationalized life insurance business.
Yes.
That's the object, not the property act. No, it is not the real property act. It's a national, life insurance business should be consolidated and given in the hands of LIC, a government company, statutory corporation. Hello. Upper cannot speak. But I mean, I requested to give another 15 minutes. My lord, do you lordship really need?
If you want anything, you please put it in writing, sir. This is good.
I keep
Enough
a note.
senior has made all submissions. We will give you an liberty to file a written note of submission, 3 or 4 pages. Don't make it 100 pages.
No. Should be
So we'll decide. The legal issue you have argued and that.
Before.
And imagine you are appearing before the estate officer. I pity that fellow.
But just give me 5 minutes more. Just not even 5 minutes. That notice of termination. I made some factual mistake in relation to that. May I correct it?
Page 115.
One.
No. Not page 115.
I'll remember. That made one mistake. 115? No, another.
No, another notice.
It has notice. Now, since the grounds were nothing to say.
Page 378, volume 3.
That's the fine. Formation of opinion thing. I'm obliged.
You also put
I have
written notes.
made this mistake. 300 ko to bol sunle to page.
378.
378 to dao.
Volume 3.
So points
where grounds are given.
Yes, obliged. And points are short, but papers. I made a mistake. This I might correct. And you see me, Lord, the second ground have been that you had a no fresh release agreement. That bogus. The next thought you have proceeded the repair jobs without knowledge and consent of the applicant. Nobody requires for repair job. Nobody requires the consent. Causing damage to the building, which is a heritage building. Nature of damage is not there. But this I want to add, sub-bin. This is the precise ground on which LIZ filed a civil civil court suit. On this ground. And civil civil court in their interlocutory judgment totally abolished that case. No particular, nothing given. Now, next minute, kindly see. That was after the suit, they failed to obtain the interim order. Then the LIC officers thought of initiating this.
Yes.
Now, can you see the last paragraph? And on this, I made a mistake here. Your authority to occupy the premises was determined by the applicant statutory authority by their notice to quit dated 21/3/2005. There is no such notice. This notice is at page 207, dated. It is a letter written by them to the police authorities. Basically, come to page 207, volume 2. And notice of termination, can you note here, there is page 115, which I give to outside. This is not the notice even. See, this 205, page 207, volume 2. Is a letter addressed by to Director General of Building, KMC, by some officer of this LIC, General Manager, thanking him that they have put a watchman to over this building. We have lost the report and we have requested you and thank you very much for putting a watchman over the building. It was written after city court suit has been pending. They want some evidence. It is not a notice to quit at all. That's what that is show. Non-application of mind is creating something. Wholly example of arbitrariness.
We will consider. Yes. We have heard the arguments also. Judgment reserved. The learned advocates on either side are at liberty to file brief written note on submissions, not exceeding 4 pages. Time for filing granted till 8th of September. 8th September?
8th September. No?
Brief notes.
Yes. And if my lord, if I indicate that if the sore point is rent is not being revised, we're agreeable, agreement is there. Let us sit together and let us formulate a different mode of revision.
But I think that stage is thrust, sir. 20 years, very difficult. Then the general manager will lose his job if he comes and discusses with your client.
Shouldn't he? Shouldn't he, if he pronounce that?
No, initially in 2003, when the notice was issued, if there was some dialogue, it could have been sorted out.
Dialogue can go on.
And not this far.
Another drastic action like eviction is not called for. Nobody's case is that my client is rich or affluent. That case is not made out. Not it is not, I mean, business enterprise, etc. That case is not 1,200 square feet shop owner.
That is very easy for them. Having engaged the services of a senior advocate, they will say client is rich and affluent.
It is it goes other way around.
In fact, they have given letter in 2022 also when the matter is coming. But
that we will see.
But so far as
we have spent so much of time, we will decide the legal issues.
But I'm really indeed grateful. My lordships have given so much patience hearing, my lord, at least so far as I am concerned. But one blessings for me, my lord, if may I seek, my lord has put us a clock to up to 8. But my lords have taken so much note. Even if we do not give any written notes, my lord, that will not make any change. But since it's a desire fallen from your lordship, instead of 8, may it be 11th.
11th.
I'm grateful. Known as Queen's Mansion. And there's hundreds of shop rooms. There are some acquired government requisition flat also where learned judge resides.
Okay.
I know. I've seen Justice Deepak Sen, as the BLJ, it was saying that they held court. That's right. And hundreds of shop rooms on the ground floor. You know, Queen's Mansion belonged to Mr. Galston. But a very rich man, Armenian, became a bankrupt. And then but they mortgaged the property to LIC. Then it was taken account. That's all. Well, 8th September.
No, 11th September.
11th September.
11th September. All right.
Grateful, lordship.
Must not exceed more than
4 pages. Deeply obliged.